Right? Honorable. Chief Justice, Associate Justice, the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having visited for the honor Supreme Court of the Philippines shall be their attendance. Report out session.
Madam Clerk of Court, please call the case before us.
Good afternoon, Your Honors. Scheduled for today's oral arguments are the consolidated petitions in GR number 261892, Kilusan sa pagbabago ng Industriya ng Transportasyon Incorporated or KAPIT, Pangkalahatang Sangguniang Manila and Suburbs Drivers Association Nationwide Incorporated or Pasang Mazda, Alliance of Transport Operators and Drivers Association of the Philippines or ALTODAP, and Alliance of Concerned Transport Organization or ACTO versus City of Manila, Quezon City, Valenzuela City, Parañaque City, Muntinlupa City, and Land Transportation Office. GR number 262192, Attorney Juman B. Paa versus Sangguniang Panglungsod ng Manila and Honorable Dr. Maria Sheilah Lacuna-Pangan, and GR number 263752, Philippine National Taxi Operators Association Incorporated, Manuel C. Cruz and Jacqueline V. Serrano versus City of Manila, Quezon City, Valenzuela City, Parañaque City, Muntinlupa City, and Metropolitan Manila Development Authority. The petitions involve the constitutionality of the implementation of the No Physical Contact Apprehension Policy or NCAP. Thank you, Your Honors.
Appearances.
Good afternoon, Your Honor. Attorney Greg G. Pua Jr. and Attorney Edgar Gino Bartolata for the petitioners in GR number 261892. Good afternoon, Your Honors. Appearing as a petitioner of this case under GR number 262192, along with my counsel, Your Honor, Attorney Mark Ison.
Good afternoon, Your Honors. My name is Attorney Lorman Tiarugay, counsel for the Philippine National Taxi Operators Association.
Good afternoon, Your Honors. The Office of the Solicitor General respectfully enters its appearance for respondents, Land Transportation Office and Metropolitan Manila Development Authority in the three subject cases. I am Solicitor General Menardo Guevara, and with me this afternoon are Assistant Solicitor General Marisa de la Cruz Galandines, Assistant Solicitor General Permes Ocampo, Assistant Solicitor General Henry Angeles, Assistant Solicitor General James Lee Kundangan. From the Land Transportation Office, as directed by the Honorable Court, we have tag-along Assistant Secretary Jose Arturo Tugade, Ms. Noreen Bernadette San Luis Lutey, Regional Director, and Attorney Aminola Abaton. From the Metro Manila Development Authority, also to serve as resource persons if necessary are Mr. Roneses Rivera, Chief No Physical Contact Apprehension Policy, and Director Milagro Silvestre, Director, Management Information System Staff. Thank you, Your Honors.
Where are the counsels for the LGU?
Honorable Chief Justice, honorable members of the Supreme Court. I am Attorney Jerry Manalili. With me is Attorney Clemente. We are representing the respondent City of Valenzuela in GR number 261892. Magandang hapon po.
Good afternoon, Your Honors. Attorney Pancho Vasquez, Your Honors, City Legal Officer for Respondent City of Parañaque in GR number 261892, Your Honor. Good afternoon, Your Honor.
Good afternoon, Your Honors. Respectful appearing for the City of Muntinlupa, I am Attorney Janice M. Santiago, Your Honors.
Good afternoon to the Honorable Chief Justice and the Honorable members of the Supreme Court. Carlo Austria, respectfully appearing on behalf of the Quezon City Government in GR number 261892. Thank you, Your Honors.
Good afternoon, Your Honors. I am Attorney Veronica Liado, respectfully appearing as the City Legal Officer for the City of Manila. Appearing with me this afternoon are Attorneys Martin Israel Bison, Attorney Frank Comia, and Attorney Kevin Manlulu from the City Legal Office of Manila.
For this afternoon's proceeding, each side shall be given 20 minutes to present their arguments. But for GR number 263752, you are only entitled for 10 minutes for your opening statement. Thereafter, the Solicitor General shall be given his chance to make his presentation. I understand you have to present some audiovisual presentation. Okay. Thereafter, the interpellation of the justices shall proceed. So who is to present as far as the petitioners are concerned? We follow the GR number.
Good afternoon, Your Honors. No doubt, the respondents would be presenting facts, statistics, and data in order to convince this honorable court that no physical contact apprehension, or NCAP, is an effective traffic regulation and that it has lessened traffic and among other beneficial effects. However, the petitioners emphasize that any benefit of the NCAP does not and should not justify the patent violation of the Constitution and existing statutes. In the case of Municipality of Tupi versus Faustino, this honorable court started its ruling, thus the end justified the means. In the said case, Your Honor, the honorable court declared invalid the ordinance of the Municipality of Tupi as it contravened the provision of RA 4136, among others. The petitioner's direct resort to this honorable court is justified since it has original jurisdiction over petitions for certiorari, prohibition, mandamus, such as the instant petition. While this jurisdiction is shared with the Court of Appeals and the Regional Trial Court, the Honorable Supreme Court, in litany of cases, ruled that a direct invocation of this court's jurisdiction is allowed when there are special and important reasons. Further, to file multiple petitions before the different regional trial courts may result in conflicting decisions and prejudice an immediate resolution of the invalidity of the NCAP ordinances. The instant case, Your Honors, involves issues which are of paramount importance. Similar to the case of Municipality of Tupi, this case involves conflict between the ordinance of the respondents versus the Constitution and existing statutes. In the said case, Your Honor, the Honorable Court ruled, in any event, while it is true that respondents availed of a wrong initiatory remedy, the need to finally resolve the issues involved here far outweighs the rigid application of the rules. There is also an existing actual and justiciable controversy, that is the invalidity of NCAP. The questioned ordinances were issued with grave abuse of discretion as it contravenes the Constitution and existing statutes, which prejudice the rights of the PUV operator members of the petitioners. The instant case is also ripe for adjudication since the petitioners, their members, and other motor vehicle owners and the general public are all directly threatened by the issuance and continued implementation of the NCAP ordinances, which violates due process, equal protection clause, existing statutes, involves improper delegation of governmental function. The questioned NCAP ordinances are also oppressive, unreasonable, and disadvantageous to motorists. No less than the livelihood of the members of the petitioners are threatened and prejudiced as the registration of their vehicles are affected by the illegal NCAP ordinances. The petitioners possess both legal capacity and locus standi to file this petition since they have their personal stakes in the outcome of this case, which involve the life and livelihood of its members. Be that as it may, Your Honors, this honorable court in several cases has taken a liberal stance towards the requirement of legal standing, especially when paramount interest is involved. The honorable court did this despite the inability of the petitioners in the said cases to show that they have been personally injured by the operation of a law or any government act. Again, the instant petitions raise issues of overarching significance to the public, hence imbued with public interest, so substantial as to necessitate this honorable court's cognizance and resolution. The instant case also involves pure question of law, as the main issue to be resolved is the constitutionality of the subject ordinances. The filing of the instant case directly to this honorable court to question the validity of LGU's NCAP ordinances, the petitioners did not commit forum shopping as there is no identity of parties and issues in the instant case and the case pending before the Regional Trial Court of Makati, which challenged the MMDA's authority to issue its NCAP as Administrative Resolution 16-01. Further, petitioner KAPIT was unsuited in the Makati case months before the instant petition was filed. Furthermore, when the instant petition was filed, the MMDA was not among the respondents named by the petitioners. Your Honors, in justifying the issuance of NCAP, respondents argued that the same is intended to create a culture of discipline among motorists and for the improvement of driving behavior. Respondents further argued that NCAP will also ensure road safety and reduces traffic violation and traffic-related accidents. Hence, the implementation of NCAP is a valid exercise of police power. While the assailed ordinances were purportedly issued pursuant to the police power of the respondents, the same are invalid exercise of police power since this violate the Constitution, the Land Transportation and Traffic Code, or the RA 4136, RA 10173, or the Data Privacy Act, are oppressive and unreasonable, are disadvantageous not only to the motorists but also to the government itself. Further, the excessiveness of the fines and penalties imposed under NCAP warrants the declaration of its invalidity. As ruled by this honorable court, a regulatory fee must not produce revenue in excess of the cost of regulation because such fee will be construed as an illegal tax when the revenue generated by the regulation exceeds the cost of regulation. The fact that larger percentage of the fines and penalties collected goes to a private contractor only shows that the fines and penalties exceeds the cost of regulation. Considering that NCAP violates the Constitution and statutes, NCAP failed to meet the test of lawful means for a valid exercise of police power. Further, how can NCAP accomplish its purpose if it targets the registered owner of a vehicle and not the actual driver who violates traffic regulations? these fatal defects defeats the alleged lofty public purpose for which the NCAP was passed. For the same reason stated, Your Honors, the NCAP ordinance did not pass the test of validity of an ordinance. NCAP also imposes unreasonable conditions, such as but not limited to undue presumption of liability in traffic violation against registered owner, the transfer and processing of personal and sensitive information of registered owner, thus violating their data privacy rights, the payment of fines and penalties as condition precedent for motor vehicle registration renewal. As stated, Your Honors, the implementation of NCAP violates the due process right of the registered owners of the vehicle. A scrutiny of the said ordinances reveals that the registered owners are made liable for the alleged traffic violation committed by the driver. However, no such law even allowed this, Your Honors. The ruling of this honorable court in the case of Legazpi versus Cebu City does not justify NCAP, since in the subject case, the subject ordinance imposed the penalty to the motor vehicle owner or driver violating the said ordinance. Second, the motor vehicle is immobilized on the spot, and the violator of the said ordinance is consequently identified when he/she protests and or pays the fine in order to use the immobilized motor vehicle. Thus, in that case, the penalty prescribed in the said case is properly imposed on the actual violator. Unlike in the questioned NCAP ordinances, the registered owner is made liable for the offense committed by the driver violator. The NCAP ordinance also violates the Equal Protection Clause. The Honorable Court can take judicial notice of the fact that despite the implementation of respondents of what they call state-of-the-art technology, they still have their own traffic enforcers who apprehend traffic violators, drivers, and impose fines and penalties. However, there's a big difference in the fines and penalties imposed under NCAP versus true face-to-face apprehension for a similar violation, Your Honors. For instance, per resolution number 918 series of 2021 of respondent City of Valenzuela, the fine for disregarding traffic signs under NCAP is 2,000 to 3,000, while if caught by a traffic enforcers, only 500. This wide disparity in fine imposed within the same jurisdiction and for the same offense not only violates the Equal Protection Clause, but also the constitutional right of motorists against excessive fines and penalties. Further, the NCAP also violates the right to informational privacy. As will be discussed, the NCAP violates the Data Privacy Act of 2012, especially in the aspect of processing personal and sensitive information of the registered owners by a private person. NCAP does not only violates the Constitution, but several statutes, one of which is RA 4136, specifically Section 29, in relation to Section 62. Your Honors, the respondents are trying to convince this honorable court that there is nothing in Section 29 which mandates how apprehensions are carried out, and that apprehension of traffic violators is not limited to face-to-face apprehension. However, careful reading of Section 29, Your Honors, would reveal that upon commission of a traffic violation, the driver's license of the erring driver shall be confiscated and a receipt shall be issued which shall authorize the driver to operate a motor vehicle for a period not exceeding 72 hours. Clearly, pursuant to Section 29, the only way that the driver's license of a traffic violator can be confiscated and a receipt be issued is through face-to-face apprehension. The law used the word shall, which connotes that it is mandatory. Section 29 also supports petitioner's position that traffic violation can only be committed by a driver. However, NCAP circumvents this process entirely by targeting the registered owner directly and making the registered owner liable for a traffic violation which is personal to the erring driver. A reading of 4136 would show that a violation of the Land Transportation and Traffic Code is penal in nature and is the personal liability of the offender. As such, there can be no presumption of liability to the registered owners. Clearly, the NCAP illegally places the public and registered owners of motor vehicles at an inceptual disadvantage in the enforcement of traffic violations. Moreover, the Honorable Court can take also judicial notice that not all vehicle owners are holders of driver's license, and in fact, some do not drive at all, such in the case of a juridical person who cannot possibly commit an actual traffic violation. The cases cited by the respondent in justifying the application of registered owner rule only applies in case of motor vehicle mishaps and not in the commissions of a traffic violation, which as shown and by its nature is personal to the erring driver. Respondents also argued that making the registered owner of a motor vehicle liable for traffic violation is for expedience and for the protection of the public, considering the difficulty of identifying the actual driver during NCAP apprehension. However, no law allows the same. There are other ways to identify an erring driver, Your Honors. In fact, the LTO has the power to issue subpoena to compel the appearance of a motor vehicle which can be used to identify an erring driver. Respondents' LGU should not hastily pass the liability of the erring driver to the registered owner and held them in hostage by alarming their vehicles just to collect the fines and penalties, especially when a big percentage thereof only goes to a private person. Your Honors, there's no justification under RA 4136 to implement a policy where non-payment of fines and penalties for traffic violation committed puts an alarm on the motor vehicle registration, hence preventing its renewal, since it should be the driver's license which should be affected. This would also allow the LTO to implement its driver's license merit and demerit system. Clearly, the said ordinance violates Section 62 of RA 4136, hence invalid. The wordings of Section 29 and 62 are mandatory, and any act executed in violation of said provision is void. The respondents also argue that the registered owner rule is applicable in case of traffic violations, citing the anti-drunk driving law, the Anti-Distracted Driving Act, and the seatbelt law. Such argument is misplaced, Your Honors. The said law amended our land transportation and traffic codes, and the said laws were issued by Congress, which has the sole right to amend or repeal existing laws, a power which the respondents' LGU do not have. And for the respondent LGUs to do so would tantamount to grave abuse of discretion. If it were the intention of Congress to make registered owner liable for traffic violation, then legislation must be passed. In fact, the Congress recently amended RA 4136. However, no amendment as to the liability of the registered owner for traffic violation was made. NCAP also violates Data Privacy Act of 2012. While the Data Privacy Act allows public authority to process personal information pursuant to public functions, the same is not carte blanche authority for the authorities to bargain away without limits such personal and sensitive information to a private person, which NCAP allows. The NCAP also violates the principle of non-delegation of governmental functions. Traffic regulation and enforcement are considered governmental function of respondents' LGUs, since these are for the advancement of the public good and welfare of the public in general. Traffic regulation and enforcement are legislative mandates which were delegated to the LGU through the enactment of the local government code. As a government function, traffic regulation and enforcement cannot be considered as a business, Your Honors. While ministerial duties may be delegated, official functions requiring exercise of discretion and judgment may not be so delegated, such as traffic violation determination. However, respondent LGU delegated to a private entity under a joint venture agreement the implementation of traffic enforcement. As per said joint venture, the private contractor pre-processed traffic violation data into a format capable of review by the LGUs for final determination of whether to issue a notice of violation. A reading of the joint venture of the respondent LGUs would show that it delegated the preliminary determination of whether or not traffic violations are committed under NCAP to a private entity. Further, there is nothing in the joint venture which will allow the respondent LGU to review traffic violation not reported to it by the private contractor. Your Honors, this should not be done. Neither should it become a precedent nor an acceptable norm in local legislation. The delegation by the respondent LGU also involves a conflict of interest, since per their JVA, the private contractor can only be paid if the fines and penalties of the traffic violation have been paid, which they themselves determine. The articles of incorporation of the private contractor also only vest with it the power limited to conduct the business of distributing cameras and traffic surveillance equipment. Nowhere in its article was it mentioned that the private contractor can exercise such power similar to that of LTO, such as traffic management and determination of violation of traffic rules and regulation, and does not have any capacity or any government mandate to perform the function of public authority per Section 4E of the Data Privacy Act. As such, the joint venture of respondents' LGUs with their private contractors are void, not only because these are ultra vires acts of respondent LGU, but also ultra vires acts of their private contractor. For these reasons, Your Honor, the NCAP ordinances must be struck down and declared by this honorable court as constitutionally infirm and invalid. Petitioner most respectfully seek the kind indulgence of this honorable Supreme Court that once declared as unconstitutional, respondents be ordered to refund all fines, penalties, and interests and surcharge collected. In the case of municipality of Tupi, after having ruled on unconstitutionality of the subject ordinance in the said case, this honorable court also explained that the nullification of a traffic ordinance does not carry the application of doctrine of operative fact, and ordered the refund of the fine paid pursuant to an invalid ordinance. It is no different in petitions, since the penalties, fines collected under NCAP are placed by the respondents' LGU in a trust fund, which is a separate and distinct from their general fund, and the greater portion of fines collected inured to the benefit of their private contractors. Hence, no inequity or injustice would be caused. If no refund will be made, the registered owners of the motor vehicles who became victims of this invalid ordinance will suffer injustice and iniquity. We would like to note, Your Honors, that majority, if not all of the victims who paid their fines and penalties, felt that they were held hostage and were forced to pay the fines and penalties just to be able to register their vehicles. And in the case of petitioners, PUV operator members, just to be able to continue earning to feed their families. Indeed, for as long as our state is a republic of laws, where the rule of law is paramount and is always above the caprices of men, the end should not and never shall justify the means. Thank you, Your Honors.
Thank you, Mr. Counsel. Let's hear from Attorney Paa.
Good afternoon, Your Honors. I'm Atty. Juman, the petitioner of GR 262192 against Sangguniang Panglungsod of City of Manila, and Mayor Maria Sheilah Lacuna-Pangan. This case for the declaration of unconstitutionality of Ordinance 8676 Series of 2020 of City of Manila. The ordinance has ripened for challenge after the petitioner suffered actual damage. Thus, the issue is no longer hypothetical and speculative. The implementation of said ordinance resulted to direct injury to the petitioner, considering substantive and procedural due process were not observed in its enactment and implementation. Petitioner was constrained to pay exorbitant fees and other charges with interest, even though he did not receive any notice of violation. The interest more than 50% higher the prevailing interest rate or legal rate, and to pay add-on fees using the machine, but what they call convenience fee. Considering the Supreme Court, Court of Appeals, and regional trial courts have original and concurrent jurisdiction involving petition for certiorari, prohibition, mandamus, quo warranto, and habeas corpus. The filing of the instant petition for certiorari is proper and it did not violate the hierarchy of courts. As a consequence of implementation of the sealed ordinance, the privacy of the registered owner of a vehicle is violated due to unauthorized sharing of his or her data among the LTO, City of Manila, and private service contractor. The sealed ordinance involves public funds, which should be primarily for the benefit of the LGU, collecting from traffic violations whose rights were blatantly violated and disregarded. More importantly, the ordinance in question requires the registered owner of motor vehicles to settle unpaid penalties and interest for traffic violations as condition precedent for the registration of their vehicle, which is highly irregular and unwarranted, if not totally unlawful, as it runs counter with existing laws for the registration of motor vehicles. The instance case challenges the official act of the City of Manila in enacting implementing NCAP ordinance, wherein it delegated the maintenance and operation of the NCAP to a private service contractor for a fixed percentage of 75% of the collected fines and surcharges, interest rate reaching more than 50% of fine itself that were deposited in the trust fund. In fact, the profit sharing ratio cannot be found on the face of the sealed ordinance, and joint venture agreement was not also made public. To successfully invoke the exercise of police power, the rationale for the enactment of the ordinance and to free it from imputation of constitutional infirmity, the Supreme Court has time again used the rational relationship test, as discussed in Social Justice Society versus Atienza Jr. In short, there must be a concurrence of lawful subject and lawful method. Ordinance number 8676 states that it declared policy under Section 2 of the ordinance. In whereas clause, it is clear that the objective of the ordinance is to enhance culture of traffic discipline among motorists and still around the clock or obedience of traffic ordinance through no contact apprehension operating 24/7. Hence, the subject of the sealed ordinance is lawful but cannot be said with the means employed by the City of Manila. The ordinance intends to use NCAP to instill discipline among motorists. Yes, it is not the driver violator who is being disciplined, but it is the registered owner who is being penalized. It is unreasonable in that ordinance lets the driver violator free from penalty while registered owner who is innocent in violating the traffic ordinance is being disciplined. Moreover, the ordinance in question imposes higher penalty than those imposed by the LTO. The respondent takes refuge stating the Section 458 of the Local Government Code, which actually misplaced. The OTC is given the power to establish and prescribe corresponding rules and regulations for enforcement of laws governing the land transportation service. Under EO 125, paragraph 5O and EO 292, title 15, chapter 1, section 3, and paragraph 14. Hence, the revised administrative code grants specifically the power to the DOTR to prescribe penalties for traffic violations, while the quoted provision in the local government code generally pertains to violation of ordinance. RA 4136 shall be the basis of every LGU in enactment of the respective traffic codes. Hence, while it is true that the local autonomy has been granted to LGU, the same is still subject to limitations. The imposition of fines and penalties on traffic violations is only for regulatory purposes, and it should not be used as income-generating scheme. The respondent is grossly indifferent to the plight of ordinary motorists in stating that the fines are not shocking to mankind. Having to pay 2,000 to 5,000 pesos plus interest penalty imposed is immoral and oppressive to working public, where the daily minimum wage is less than 600 pesos. What is morally shocking is the institutional indifference of local government to the plight of the people they intend to serve. The procedural due process provided in the ordinance is likewise flawed. A trial hearing is not required, but at the very least, the opportunity to be heard is present. The ordinance is silent on the procedure by which the motorist may contest and oppose the notice of violation. Assuming there is indeed a process of appeal, the ordinance still fails in ensuring procedural due process is observed, the so-called neutrality of an impartial judge is not assured. The ordinance provides that the City of Manila Traffic Adjudication Board has exclusive jurisdiction to hear and decide cases involving violation of traffic rules and regulation. However, in the same section, it is provided that the NCAP Trust Fund shall pay the monthly honoraria to the members. Then, the said fund pays the honoraria of judges that will rule on the traffic violation contest. This is a clear case of conflict of interest, which undermines the impartiality of the City of Manila Adjudication Board. So the requisite of the valid ordinance under Fernando versus Saint Scholastica, 706 Philippine 138, must be present. None of the aforementioned requisites were satisfactorily met by the respondent. An ordinance in question violates the Equal Protection Clause enshrined in our Constitution. The guarantee is embedded by Article 3, Section 1 of the Constitution. Like in the case of the petitioner, the fine must be settled regardless of whether the notice was served or unserved to the proper party, thereby violating the right to due process. The essential element of the procedural due process under NCAP should be the receipt of notice of violation to ensure that the subject person shall be given opportunity to be heard. The petitioner was only notified of his violation when he personally went to MTBB. Hence, the running of prescriptive period should commence only then, and the right to contest notice of violation should be allowed. The NCAP ordinance violates the 2 months prescriptive period for violation of municipal ordinance. They are required us to pay penalty even beyond the prescription. Furthermore, the application of overbreadth doctrine finds application in this instant case, as the respondent, in contravention of RA 1463, imposed additional requirement for registration of motor vehicle and committed usurpation of the power of the LTO to resolve and decide protests on traffic violation, albeit having no quasi-judicial power over the same. As cursory reading of the provision of Section 29 of RA 4136 shows that only face-to-face apprehension is the viable mode to apprehend erring drivers. Otherwise, the very purpose of the law would be defeated. An amendment of 4163, RA 4163, or the enactment of new law is required for the implementation of the NCAP. Notably, Section 29 of RA 1436 refers only to drivers and not registered owners of motor vehicles. A driver who is caught in flagrante delicto allows traffic enforcer deputized by LTO to apprehend and issue citation tickets for violation. Thus, it is the driver who actually committed the violation who shall be fined and penalized. Under the NCAP, however, the City of Manila dispenses with the obligation to ascertain who committed traffic violation by simply passing the liability to the registered owner of the motor vehicle. The NCAP has been used arbitrarily by the respondent as it issues notice of violation to the traffic violator or the registered owner of the vehicle, to be more precise, on the precept that if the person subject of violation was not able to timely protest the same, said person shall be compelled to pay the penalties even if no traffic violation was committed at all. In the petitioner's case, the renewal of his motor vehicle registration could have hindered his right to practice his profession for his mobility would be affected. In essence, the said ordinance is amendment of existing law on registration of motor vehicle, the jurisdiction over which lies predominantly with the legislative. However, the registered owner cannot validly apply it under the NCAP, as it is responsibility of the local government to ascertain the identity of the driver who actually committed the traffic violation, the one who alleges the burden to prove its claim. As of present, there is no law prohibiting owners of private vehicles from allowing other persons to drive for their cars. An open deed of sale has been the norm in the sale of second-hand vehicle. Thus, being the registered owner of the vehicle involved in the traffic violation does not necessarily mean that the latter was a driver who committed the violation. It is further submitted that the registered owner is not a proper party to contest the finding of violation because he may or may not be the actual driver who committed the traffic violation subject of the notice of violation. This makes the notice of violation and a 10-day period to appeal farcical and superficial. It is nearly impossible for the register owner to explain the violation, as he himself may not be the driver at the time of the captured violation. By virtue of the service agreement which we received yesterday, respondent acted in exercise of his power when it granted the implementation of the function, particularly the exercise of police power, to the private contractor. In this case, the private service contract was never deputized by the LTO to apprehend motorists by violation of traffic laws through CCTV. The authority granted to MTPB cannot be extended to the City of Manila to a private service contractor, especially without the permission of the LTO. The joint venture entered into by the City of Manila for the implementation of the NCAP is essentially delegation of private service contractor of the police power delegated by the legislative only to the LGU. Thus, it is unlawful. Furthermore, the profit sharing agreement under JB appears to be prejudicial to the public as it is placed private service contractor at a greater advantage. The NCAP Trust Fund has no other stated purpose but for the payment of honoraria members and the secretariat of the committee. The very purpose of the trust fund was not defined, and even the payment of the share of private service contractor was not properly identified. Considering the ordinance did not set any limitation or parameters for each utilization, the ordinance that would protect the interest of the government and the general public. Hence, the monies deposited in the trust fund cannot be legally transferred to the private service contractor pursuant to the joint venture. Taking all of this consideration, the ordinance should be held unconstitutional as it is an ultra vires act of the respondent. The imposition of unreasonable high penalties with more than 50% interest and other charges is unfair. There was no basis for the same, considering the nature of traffic violation remains to be the same. Or in other words, the traffic violations did not become more serious upon implementation of the NCAP. The penalty must be proportionate with the infractions committed. It places those who cannot afford to pay exorbitant penalties at a disadvantage against those who have means to pay for the violations. In addition to penalty, NCAP also imposed interest on unpaid penalties, which was not provided in the ordinance. Pay is also directed to use the machine installed by the City of Manila using payment channel with 35 pesos to 45 pesos convenience fee per transaction. The goal of disciplining errant motorists is defeated, as respondent merely collects penalty for traffic violation, but it does not provide corrective programs and seminars for the education of traffic violators or project for the installation of uniform standard traffic and road signs, and even the traffic lights with timer. Apparently, as long as traffic violators can pay the penalties, no other sanctions would be imposed upon them. This strongly suggests that the NCAP ordinance was created for commercial purposes for the benefit of the private company. For instance, the penalty of the traffic violation caught in the face-to-face apprehension for local traffic enforcers of the city amounts to 1,000. The whole amount of 1,000 shall be form part of the funds of the LGU only. On the other hand, if the violation was caught through NCAP, a penalty amounting to 2,000 shall be imposed, and only 25% of which, or 500, shall be for the government, while the 75 shall go to the private service contractor. Therefore, the joint venture or service agreement pursuant to the assailed ordinance is a clearly disadvantageous to the government. The reason of the increase of the compensation of the private service contractor and some portion which is supposed for the share of the government, which was diminished by 50%. The City of Manila must ensure that notice of violation would be issued only to driver of the vehicle, code-through program. Until then, the City of Manila and private service contractor cannot, or should not process private information of the registered owner of the vehicle. The data subjects in this case are the registered owners of the vehicle. Their personal information are being shared by the LTO to and processed by the LGU and its private contractors. As a general rule, the consent of data subject are required prior to the processing of personal information. Consent is needed because the processing of information is being conducted by the third private entity contracted by LGU. Hence, the exception of Section 4 of RA 10173 does not apply. In fact, the respondent's ordinance itself does not provide statutory authority to private contractor to implement NCAP. It only provides that the City of Manila will implement NCAP through the creation of Motor Vehicle Registration Alert System. The ordinance merely allowed the LGU to enter into a joint venture, the service agreement, a contractual relation to a third party to implement NCAP. In the absence of statutory grant of power, the private contractors cannot be included among those exceptions provided under Section 4, Paragraph E. Petitioner disagree with the contention of the respondent, such as service provider acts as an agent of the local government unit and the information process by it likewise excluded from the coverage of Data Privacy Act, stating further that the law does not make distinction about whether the processing of information is done by the government agency or its duly authorized agent. Data sharing of database is highly regulated under DPA. The DPA allows the data sharing agreement provided that such agreement shall comply with the requirements of the law. We are applying here the case of Christian Cadajas versus People under GR 247-348 regarding the informational privacy violated by the local government. Since the third-party contractor are not per se government agencies that are excluded from the scope of the application of the DPA, the consent of data subject must be obtained prior to processing of personal information. In addition, the private contractors must have complied with the registration requirement stated in the IRR, particularly Section 46, Enforcement of Data Privacy Act. It is submitted that the mere invocation of the rules on agency does not excuse the private contractor for complying with the requirements of registration. Section 14, Section 24 of the Data Privacy Act requires the agency and contractor to comply with the other provisions of the Act. The safeguard under Section 20 of the DPA must be shown by respondent and their contractors. Also, under Section 14, the contractor must ensure confidentiality of the personal information process. These two provisions were violated by NCAP website of the City of Manila by processing the information of data subject in their website, and by simply entering the plate number to their website, it discloses the information to anyone, whether or not the owner has a violation. It is submitted that the information that a certain vehicle has a violation is a sensitive personal information as defined by the DPA. Thus, before the private contractor can disclose the sensitive personal information in its website, it must comply Section 13, the sensitive personal information and privileged information. The joint venture agreement allowing the third-party contractor to develop and maintain website which discloses the sensitive personal information without the consent, the data subject is contrary to Data Privacy Act and therefore should be struck down as contrary to law. The said ordinance should be declared unconstitutional on the ground that it is violative of substantive due process and the right to privacy of the data subject. This court has struck down ordinances that are in violation of laws passed by the Congress. The basis is that the ordinance failed to meet the requisite substantial due process, lawful subject, and lawful means. Your Honor, with the kind indulgence of this honorable court, may I ask for extension for 2 minutes, Your Honor, to complete. Thank you, Your Honor. The said ordinance resulted to injustice and inequity Thus, the operative fact doctrine cannot be applied in this case. Apprehension and collection under NCAP cannot be upheld because the service contract to which they were made is unlawful, considering the sealed ordinance is unconstitutional for being overbreadth. Considering the operative fact doctrine finds no application in the instant case, the notice of violations issued prior to issuance of the TRO can no longer be enforced, as they may now consider a mere scrap of paper and therefore do not have legal bearing. Moreover, there is a lack of guarantee that the same is issued only to the person who committed traffic violations, and collections to be made thereon will still be without basis and illegal. As a final note, Your Honor, petitioner filed this case out his moral responsibility to protect not only the right of the person, but also for the others to prevent further injustice, abuse of government entities or agencies through unlawful issuances in the guise of exercise of regular government function. The petitioner submits his argument to the sound wisdom of the honorable justices of the Supreme Court. It is enough that a man endeavor to do justice always. He must be willing to suffer rather than do anybody injustice under Justice J.P. Laurel, Your Honor. That would be all for this case. Thank you.
Thank you, Mr. Counsel. Do we hear from Attorney Arugay or?
Good afternoon, Your Honors. I will not stand here and attempt to beguile this court into believing that what is in question today is the most important constitutional question.
Mr. Counsel, can you remove your mask? I cannot understand.
My apologies, Your Honor. Good afternoon once again. Your Honor, I will not stand here and attempt to beguile this court into believing that what is in issue today is the most important constitutional question in the land. It is not. Far from it. The matter of traffic violations, Your Honor, pales in comparison to real questions of human rights, war, hunger, post-COVID economic downtrend, worsening literacy rate, and a myriad of other issues. Those issues are far more pressing, if not as pressing, as the issues here today. What is at stake today is the simple, non-trivial, and almost mundane matter of the validity of various traffic ordinances. Ordinances which, however, this representation believes to be constitutionally offensive. So while the subject matter may be simple and mundane, we are obligated to treat seriously any perceived violation of the Constitution. For if we could not even create, implement, and maintain as a people simple traffic ordinances in compliance with the Constitution, we could not expect to progress into more pressing, delicate, and more difficult questions. It is part of progress that we do the simple things right. We rise today, Your Honors, on the simple issue of whether it is right and constitutional for local governments to act all at once as the complainant, prosecutor, and judge by enacting the NCAP ordinances, providing for its punishment, creating a mode for its apprehension, and implementing a procedure for its prosecution and adjudication, all within the LGU. Our humble submission is that those actions collectively encroach upon the jurisdiction of the courts of justice, rendering them constitutionally offensive for violating the separation of powers, illegally supplanting the constitutional powers of Congress to define, prescribe, and apportion the jurisdiction of the courts, disregarding the constitutionally enshrined rule-making powers of this honorable court, violating national statutes, and for trampling upon the fundamental tenets of due process. The assailed ordinances uniformly grant the exclusive authority and jurisdiction to hear and decide cases involving NCAP to their respective traffic adjudication boards. The Constitution identified the Congress as the sole legislative body constitutionally empowered to apportion the jurisdiction of the courts of justice. This is clear from Section 2, Article 8 of the Constitution. The power to apportion the jurisdiction of the courts has been recognized as an implement of the principle of checks and balances, specifically the power of Congress to check the judicial branch of government by reserving the prerogative to apportion the latter's jurisdiction. In exercising this congressional prerogative recognized under the aforementioned provisions of the Constitution, the legislature has passed several laws, including Batas Pambansa 129 and its amendments, which to this day remains to be the general law on the jurisdiction of courts. Under Section 32 of the said law, criminal jurisdiction, the first-level courts retain the exclusive jurisdiction over all violations of city or municipal ordinances committed within their respective jurisdiction. Meanwhile, Section 36 confers upon the same courts the jurisdiction over all violations of traffic laws, rules, and regulations for which the Supreme Court was given the prerogative to designate one or more branches to try exclusively such cases. Consistent with the foregoing provisions of law and pursuant to the rulemaking powers of this Honorable Court, the Honorable Supreme Court implemented the revised rules on summary procedure and the rules on expedited proceedings in the first-level courts, which uniformly affirm the exclusive jurisdiction of the first-level courts over violations of traffic laws, rules, regulations, as well as municipal ordinances, therein labeling the same within their heading criminal cases. Clearly, the first-level courts have the sole, exclusive, absolute jurisdiction over all violations of city and municipal ordinances to the exclusion of all other governmental agencies, including the LGUs. There being no subsequent congressional legislation that reappoints this power to any other court or tribunal. Thus, by enacting the assailed ordinances, which grant the respective cities' traffic adjudication boards exclusive jurisdiction over all cases involving the same matters, the respondent cities have overstepped their boundaries and have hopelessly encroached upon the powers of Congress to apportion the jurisdiction of courts as well as the rulemaking powers of this court. While it may be argued that the delegation to the local government units is recognized as a valid delegation of legislative powers, the same, however, is subject to the limitations expressly provided by the law delegating the same, namely the Local Government Code. It is also limited by the purpose of the delegation, which is to enable the authorities to attend to local concerns in an effective manner. Section 16 of the Local Government Code, known as the General Welfare Clause, encapsulates the delegated police power to local governments. Meanwhile, local legislative bodies under Section 458 have been granted the express power to enact ordinances pertaining to the regulation of traffic within their jurisdiction. We, however, submit, Your Honors, that while the Local Government Code has delegated some legislative powers to the LGUs to enact ordinances regulating the use of streets and other facilities, as well as traffic in general, nowhere in the Local Government Code did Congress ever empower the LGUs to enact legislation that will contradict national statutes such as BP 129 and its amendments, enacted by the Congress itself, as well as the Congress's constitutionally guaranteed prerogative to apportion the jurisdiction of the courts of justice. The Local Government Code also did not confer upon the LGUs the powers to adjudicate such violations. Since the Congress is vested upon the regular courts the exclusive authority to hear and decide cases pertaining to both violations of traffic laws, rules, and regulations, as well as local ordinances, the LGU cannot arrogate upon itself the power to apportion the same jurisdiction to its own traffic adjudication boards under the guise of exercising its delegated legislative powers under the Local Government Code. Thus, in a case where the Supreme Court struck down a local ordinance for violating a national statute, this honorable court stated the spring cannot rise above its source. As a necessary consequence of the illegal assumption of jurisdiction by the LGU, a patently defective adjudication process, a farce of a trial, if I may, was implemented. One, as discussed in our petition, the procedure in question begins with the issuance of a citation against the registered owner of the vehicle, accusing him or her of the commission of an offense, which is supported by no other evidence aside from the alleged photograph or footage that the vehicle registered in the name of the accused transgressed a traffic law. Two, the accusation is made without proof as to the identity of the person who was actually driving the vehicle at the time of the incident. And as such, the accusation sweepingly jumps into the conclusion that the vehicle owner is thereby liable. An example, Your Honor, Petitioner Cruz is the registered owner of 10 taxi units, which are all being driven by 10 driver contractors. If all driver contractors committed an NCAP violation on the same day, Petitioner Cruz would be accused of having committed 10 separate violations involving 10 different vehicles in 10 different locations, and he stands to be penalized 10 times over. All these while he was innocently napping in his home on the day of the alleged violation. 3, in the event that the accused registered owner fails to submit an objection within the prescribed time, the accused will be deemed to have admitted the offense without even the need for the accuser to prove his guilt. With due respect, in what criminal proceedings is it ever permitted that failure or refusal of the accused to plead or answer would be deemed as an admission of liability? 4, as is implied by the foregoing NCAP procedures, the burden of proof is shifted upon the registered owner to prove his or her innocence rather than for the accuser to prove the registered owner's guilt. 5, even assuming that the registered owner is able to timely submit his or her objections, he or she is required to attach as evidence a notarized admission of guilt by the person driving the vehicle at the time of the incident. Otherwise, his or her objections will be denied. With respect, the purpose of a trial is precisely to determine the guilt or innocence of the accused. Any law that authorizes conviction on the basis of a presumption of guilt, or one given without a trial, or worse, on the basis of the alleged failure to provide an admission of guilt by the driver, whose evidentiary value could be supplied by other documents, papers, or testimony, is simply illegal and unconstitutional. 6, in the rare occasion that the accused registered owner is able to procure the necessary notarized admission of guilt as required under the ordinances, the registered owner's exoneration is still not secured, since failure on the part of the driver to pay the adjudged penalty of fine will still render the registered owner liable to pay the same. After the registered owner has proven his innocence, despite the handicap of needing to overcome a presumption of guilt, may I ask, Your Honor, just 2 minutes to wrap up.
Proceed.
After the registered owner has proven his innocence despite the handicap of needing to overcome a presumption of guilt, he will after all be held liable unless the person who confessed to the alleged offense complies with his sentence of fine. And yet here, this is the kind of proceedings that results when judicial powers are exercised by entities other than magistrates duly empowered by law and trained to discharge the duty of a judge. This representation, Your Honors, once defended pro bono and accused for alleged violation of a local ordinance on the mandatory wearing of face masks. The charge was filed in court, but it was subsequently dismissed after the prosecution failed to prove his guilt beyond reasonable doubt. Yesterday, This representation personally witnessed several accused pleading guilty to the violation of Quezon City's ordinance on non-smoking. Each were sentenced a penalty of fine. In those various cases, the results were varied. One was convicted, some pleaded guilty, and was thereafter sentenced with fine. But regardless of the result, it can be appreciated that justice was served in accordance with the best traditions of the legal profession, and a judgment worthy of its name was rendered. That, on the other hand, is the result when judicial power is wielded by the proper authority. We do not ask for much, Your Honor. We ask only that this tradition is preserved.
Mr. Counsel. Solicitor General. Proceed, Mr. Solicitor General. You are representing all the respondents for purposes only of this oral argument.
Good afternoon, Your Honors. As I earlier manifested, the Office of the Solicitor General is representing the MMDA and the LTO. But as agreed during the preliminary conference, I will be making my opening statement also on behalf of the local government units who are respondents in this case to save time. And also, as agreed during the preliminary conference, we have been given a few minutes to make an audiovisual presentation. So before I do my opening statement, Your Honors, may we be allowed to do the audiovisual presentation now?
Please proceed.
Thank you, Your Honor. In the meantime, while you are viewing the audiovisual presentation, may I request 2 minutes just to run to the bathroom for a bathroom break?
Go ahead.
Thank you.
You want to have a recess? Let's have a final. We'll have a recess. You may proceed, Mr. Solicitor General. The way, Mr. Solicitor General, excuse me. Please inform the court who prepared the video. It will be in the nature of demonstrative or demonstrative evidence. Have it authenticated first.
Your Honor, our intention in presenting this audio-visual presentation is just really to, not really as evidence, because we're not doing any trial at this time, but only as a preface to the opening statement on behalf of the respondents, Your Honor. Just to provide a context for the opening statement.
But just for the record, let us know who prepared the materials.
All right, Your Honor, we requested the respondent local government units in whose custody most of the data and the information are located to take charge of the presentation of this, the preparation of this audiovisual material. And in so doing, it is my understanding that they engage a professional group called Cinematica to come up with this audiovisual presentation.
Are they based on actual footages
Yes,
of the camera?
that is, sorry, Your Honor. This is basically a documentary. So they are excerpts from actual video clips, news reports, data from official sources.
Okay, thank you.
Thank you, Your Honor.
Recurring abuse of power by traffic enforcers, and increasing number of road accidents. These are just some of the problems that we Filipinos experience in our everyday commute. Yet we seem to be indifferent, resigned to the fact that this is our reality and has been for decades. A motorcycle rider loses his leg.
Members of the Philippine Air Force died in a car crash.
In the Philippines, road crashes are one of the leading causes of death, even higher than dengue. According to the Philippine Statistics Authority, the country reported 9,126 road crash deaths in 2021, of which 1,670 were children up to 19 years old. That is the equivalent to 25 preventable deaths a day. But what is the main cause of these accidents? And can they be avoided? Reports show that driver error, which includes disobedience to traffic rules, is the #1 cause of road accidents. In Metro Manila alone, there were 58,447 road crashes in 2021, despite the pandemic, resulting in 385 deaths and 15,250 non-fatal injuries, an increase of 14% in the number of deaths versus 2020. Pedestrians are the most vulnerable road users. Motorists' driving behavior and manual traffic enforcement put them at a high risk not only in Metro Manila but nationwide. Every day, 42 individuals are injured on the roads of Metro Manila. Every day, one person dies. We're not only risking our safety, we are losing lives.
Bakit nga namin ganun? Sabi niya, ma, yung jeep kasi biglang lumusot daw.
The damaging effects of road crashes range from health, personal trauma, to economic consequences. According to the TomTom Traffic Index of 2021, Metro Manila ranked as the 18th most congested city out of 404 cities worldwide. This represents 98 hours per motorist lost in traffic each year. As we start to revitalize our economy crippled by the COVID-19 pandemic, the volume of vehicles on the road has increased. About 300,000 motor vehicles and 1.44 million motorcycles were added to our congested roads in 2021. It is projected that this number will even increase by 29% in 2022. With the increasing number of road crashes and the surging number of new vehicles, how do we make our roads safer for Filipinos? The Metropolitan Manila Development Authority, or MMDA, proposed an internationally accepted and effective traffic management solution called the No Contact Apprehension Program, also known as NCAP for local implementation. NCAP is a smart and contactless approach to help authorities enforce traffic rules and regulations that supplements manual apprehension without impeding vehicular flow. The United States, France, United Kingdom, Malaysia, Australia, Thailand, among others, have long been implementing NCAP. In Singapore, which has been using cameras, violation rates have declined by a significant level, even in areas with the absence of these cameras. Where were we when the rest of the world already had NCAP as their traffic enforcement system? NCAP was introduced in the Philippines in 2016 with the hopes of aiding our congested roads and addressing irresponsible road habits. This policy allows enforcers to be safe from the risk of getting stuck by moving vehicles on the road, possible respiratory health complications, and even the rage of disobedient and rude drivers, while providing 24/7 eyes on the road. But traffic law enforcement faces another challenge.
Tinanggal sa pwesto ang 4 na traffic enforcers na aktong nangungoto.
The bribery turned road habit locally known as koto. NCAP aims to address this long-prevailing issue by preventing extortion and corruption between motorists and traffic enforcers. Through advanced video analytics, NCAP consistently enforces traffic rules 24/7 and uses an evidence-based approach to eliminate bias, thus ultimately instilling a culture of discipline and safety among motorists. But how does NCAP exactly do this? NCAP uses state-of-the-art cameras that are programmed to cover identified violation zones within its area. These cameras use video detection software that analyzes video images and classifies vehicles located on them through artificial intelligence and machine learning. The NCAP system automatically detects traffic violations without human intervention, not to mention violations which traffic enforcers on the ground could miss due to traffic or other obstructions. Once these high-definition cameras automatically detect a violation, they simultaneously take high-resolution pictures and videos of the violation. NCAP is capable of capturing multiple violations, including passing through red lights, counterflow driving, disregarding traffic signs and signals, disregarding lane markings, pedestrian crossing violation, obstruction of pedestrian lanes, driving in bicycle lanes, and speeding. More violations other than these can still be captured by NCAP, but are yet to be implemented by the LGUs. Violations such as number coding, failure to use a proper helmet, illegal loading or unloading, and more can be recognized by the system. Through the seamless interconnectivity with the Land Transportation Office, the identity of the registered vehicle owner is verified using the vehicle's plate number. Once verified, The traffic authorities review the pictures, videos, and retrieved LTO data for approval. Upon review and approval, a notice of violation containing information about the violation is generated. This will then be sent to the registered vehicle owner's address appearing in the LTO database. Notified vehicle owners can view the high-definition video and pictures through the website by inputting the NOV number and PIN code indicated in the notice. They may even contest the violation before the LGU Traffic Adjudication Board or the MMDA Traffic Adjudication Division. Fines may be paid online through the website, through accredited banks and payment centers, or at designated LGU Treasurer's office. In case a vehicle has a violation alarm, it will be lifted automatically after payment to MMDA or LGU. From MMDA's introduction in 2016, different cities have followed and started implementing a similar system. Parañaque City adopted NCAP in March 2018, Valenzuela City in October 2019, Manila City in December 2020, and Quezon City in July 2022. When NCAP was implemented by the MMDA, there was a significant 10% decline in average daily violation from 348 to 314 from January 1 to August 29, 2022, as compared to the same period in 2021. The LGUs that followed suit also saw remarkable declines in road accidents and violations within a short period of time. According to the Manila Traffic and Parking Bureau, the number of accidents on thoroughfares covered by NCAP dropped by 62% from 2019 to 2021. Similar to what the city of Manila experienced, Valenzuela City posted a 21% decrease in accidents, while Parañaque City reduced road accident-related deaths by 44% and non-fatal accidents by 13%. The province of Bataan also reported an 82.5% reduction in road accidents in February 2022, just 1 month following the launch of NCAP in their province in January 2022. Overall, the local government units that have implemented NCAP experienced dramatic declines in traffic violations within the first few months of operations. The city of Manila reported a 95% reduction in average daily violations caught per camera, from 56 down to 3 captured violations from December 2020 to August 2022. Valenzuela City also posted an 82% reduction in average daily violations, comparing its data from October 2019 and August 2022. Quezon City isn't far behind, recording a 75% reduction in average daily violations per camera, from 32 violations to 8 from July 2022 to August 2022. Meanwhile, ever since Parañaque City launched its NCAP system in March 2018, it has seen the number of violations drop by 84% as of August 2022. 84% of these total violations apprehended by NCAP involved private vehicle and motorcycle owners, while taxis, jeepneys, and UV Express account for nearly 9% of the total violators. The 2022 NCAP data from Manila City shows that drivers tend to learn from their infractions, with 79% being non-repeat offenders and 13% have 2 violations, a clear indication of improved motorist behavior. In the latest Pulse Asia survey, 8 out of 10 Filipinos are in favor of NCAP implementation, adding that the program is effective in promoting a culture of discipline and improving road safety. However, upon the issuance of the temporary restraining order against the NCAP, the MMDA reported a surge in average daily violations, especially in participating cities of Parañaque, Manila, Quezon City, and Valenzuela, reversing the gains that have been achieved by the program. While only key intersections and roads are covered by these cameras, it is evident that the program has changed the overall mindset and driving behavior of motorists. The road transport system in the Philippines leaves a lot to be desired. That is why we need to introduce tried and tested solutions to improve it. A solution is already at hand, and the results are undeniable. The No Contact Apprehension Program, or NCAP, is a proven and effective solution to help improve road safety and discipline through consistent implementation of road rules and regulations 24/7. Here is a system that is ready to change what has been our reality for decades. However, putting the system on hold will only add to the increased risk of road crashes and fatalities every day. Will we wait until more lives are on the line? Let us not withhold anything we can do to save lives when it is within our power to do it. No one is just a number. Today, we are a step closer to safer roads. And now is the time to let the brakes go and move forward with NCAP.
You may proceed. Thank you.
Thank you, Your Honor, for viewing. Mr. Chief Justice, members of the most honorable Supreme Court, good afternoon. This court, much like the courts in other jurisdictions, has time and again upheld the paramount interest of the state to promote the public good and general welfare in our highways and thoroughfares. The safety of travelers and pedestrians does not only justify the regulation by the state and by its subdivisions of the use of our public roads. Upon this most important consideration is also founded extensive judicial recognition that the use of vehicles and consequently of public thoroughfares is nothing more than a privilege. Such privilege as this court has held in a long line of cases, and most recently in bagong reformang samahan ng mga tsoper at operator, etc. versus City of Mandaluyong, quote, confers no proprietary right or interest or franchise in our public highways, unquote. More importantly, such privilege is granted under the strict condition that its grantee or license holder will continuously comply, not only with existing, but also with any new and additional burdens imposed by national laws and local government ordinances. As this honorable court held in MMDA versus Garin, citing State ex rel Sullivan, quote, motor vehicles are instruments of potential danger. The right to operate them in public places is not a natural and unrestricted right, but a privilege subject to reasonable regulation under the police power in the interest of the public safety and welfare. The power to license imports further power to withhold or to revoke such license upon non-compliance with prescribed conditions, unquote. Mr. Chief Justice, honorable members of this court, petitioners challenged the ordinances implementing various non-contact apprehension programs known as the NCAP. These ordinances, promulgated by local governments in Metropolitan Manila, were enacted pursuant to the police power delegated by the state to local governments. This delegation of police power finds clear expression in the General Welfare Clause under Section 16 of the Local Government Code of 1991. Petitioners likewise fault the arrangement which grants local governments access to vehicle registration data stored with the Land Transportation Office. This data is essential in the identification of the owners of vehicles which have violated local traffic rules and regulations and captured by NCAP cameras. This arrangement, in petitioners' view, allegedly infringes on their right to privacy. Finally, petitioners claim violation of their due process rights, presumably because the NCAP mechanism creates a presumption of liability on the part of the registered vehicle owner. The Republic will not only establish the lack of legal mooring of these challenges, it will likewise show that the petitions presently lodged before this honorable court, as well as petitioners themselves, are ruefully inadequate to invoke the court's expanded power of judicial review. For the current petitions are not only without merit, more importantly, these petitions attempt to skirt the most rudimentary requirements for the invocation of this honorable court's power of judicial review. As the state has extensively discussed in our comments submitted to the court, petitioners do not fulfill the requisite locus standi. Locus standi demands that those who petition relief from this court establish not only a right, but also a clear, actual, or threatened injury arising from the violation of such right. This requirement is not to be lightly trifled with. Only upon showing of a clear injury can the court appreciate fully the adverseness between, on the one hand, the right of the petitioner, and on the other, the power exercised by the state. Only with such appreciation can the court declare whether constitutional limits have in fact been crossed, and thereafter craft the remedies necessary to restore such limits. Petitioner KAPIT et al.'s lack of locus standi is evident in their failure to allege any actual or threatened injury directly traceable to the implementation of the NCAP. Meanwhile, petitioner PAA's claimed injury, namely the penalty that he is bound to assume, exacerbated by imposable surcharges and interests, arises from his own violation of traffic rules, magnified by his failure to register his correct address with the LTO. Petitioner's lack of locus standi cannot be cured by an erroneous invocation of the rule on third-party standing. As a general rule, a constitutional challenge to a government act as applied is permissible only upon assertion of a violation of the challenger's rights. The rule prohibits one from challenging the constitutionality of the statute based solely on the violation of the rights of third persons, not before the court. This rule is also known as the prohibition against third-party standing. The prohibition admits of a notable exception, that of a facial challenge against a statute. But this exception is applicable only when the right to speech is implicated, which is definitely not the case before this court. More importantly, petitioners have failed to exhaust the administrative remedies available to them. They have likewise flouted rules that demand respect for the hierarchy of courts and desistance from acts that constitute forum shopping. Their recourse to this court relating to supposed violation of their rights under the Data Privacy Act are more appropriately addressed to the National Privacy Commission or NPC, which exercises primary if not exclusive, jurisdiction over alleged violations of the Data Privacy Act. Meanwhile, KAPIT and its counsel, Malcolm Law Offices, have previously assailed the NCAP before the Regional Trial Court at Makati City. While KAPIT's petition for injunction has been dismissed by the RTC without prejudice, the case of its co-petitioner and counsel of record, Malcolm Law Offices, remains pending with the lower court. Their direct resort to this court, and worse, non-disclosure of the previous case involving similar issues, manifest an abuse of the legal process, which, if permitted, may pose a threat to the orderly functioning of our judicial system. Mr. Chief Justice and honorable members of this court, the power of local governments to promulgate ordinances in the regulation of road traffic is beyond dispute. It is embraced under the General Welfare Clause and expressly provided in Section 447, Paragraph 5, Item 6, and Section 458, Paragraph 5, Item 6 of the Local Government Code for municipalities and cities respectively. The exercise of this power is subject only to the requirement that it does not violate any national law or policy. This is because local governments, in the exercise of the delegated police power, act merely as agents of the national government. As agents, they cannot rise above the principle. The NCAP ordinances, which establish a system for the capture of live traffic violations and the subsequent identification of the owners of the vehicles involved in such violations for the purpose of ultimately identifying the offending driver, do not in any way contravene any national law or policy. On the other hand, Metro Manila Development Authority Resolution number 16-01, which implements the NCAP in the major thoroughfares of Metropolitan Manila, and its precursor, Resolution number 02-49, were validly issued by the MMDA. Republic Act number 7924 empowers the MMDA through the Metro Manila Council to issue rules and regulations that provide for a system to regulate traffic in the major thoroughfares of Metro Manila for the safety and convenience of the public. This honorable court has already recognized this power lodged in the MMDA in the case of Pantaleon versus MMDA. Petitioners cannot therefore be permitted to challenge the validity of MMDA Resolution number 16-01. Neither may petitioners challenge these resolutions and ordinances for being inconsistent with Section 29 of Republic Act number 4136 or the Land, Transportation, and Traffic Code. Section 29 governs the confiscation of existing driver's licenses as an incident due to a driver's traffic violation. In contrast, the subject ordinances merely provide the LTO a ground for refusing vehicle re-registration. They neither take away the privilege of an owner to use a registered vehicle, nor do these ordinances direct the confiscation of driver's licenses by the local governments. It is thus the submission of the Republic that the validity of the challenge ordinances cannot be made on the basis of Section 29 of RA 4136 or the Traffic Code. Mr. Chief Justice, honorable members of this court, the arrangement between the LTO and the respondent local government for data access may not be challenged on considerations of privacy. The 1987 Constitution has institutionalized the right to privacy or the right to be let alone as a facet of the right protected by the guarantee against unreasonable searches and seizures. But as early as 1968, this court acknowledged its existence when it ruled in Morphe versus Mutuk that the right to privacy exists independently of its identification with liberty. It is in itself fully deserving of constitutional protection. In assessing any claim of impermissible intrusion by the state on the right to privacy, this court has always inquired whether the person claiming violation of the right has exhibited a reasonable expectation of privacy, and if so, whether that expectation has been violated by unreasonable government intrusion. NCAP cameras capture vehicle images that violate traffic rules and regulations. They are neither designed to capture, nor are these cameras capable of obtaining facial recognition images of the drivers. This fact attenuates and weakens petitioners' claim of violation of their right to privacy. Moreover, petitioners have not established an expectation of privacy while exercising the privilege of openly using vehicles in public roads. More importantly, the sharing by the LTO of vehicle registration data with the local government involves information necessary to carry out functions of public authorities. It is therefore a sharing of personal information which is expressly excluded from the coverage of the Data Privacy Act. This, in addition to petitioners' failure to bring their claim of data privacy violation before the NPC, constitute indubitable grounds to deny any supposed violation of petitioners' right to privacy. Finally, petitioners may not assert violation of their due process rights arising from the presumption of liability on the part of the owner of the registered vehicle which was used in violating traffic rules and regulations. Admittedly, the rule ascribing liability to the registered vehicle owner, first enunciated in the 1957 case of Erezo et al. Versus Hepte, has been consistently used in tort cases. But the rationale for the rule justifies the application beyond accident cases, as held by the court in Erezo, citing King versus Brenham Automobile Company. Quote, one of the principal purposes of motor vehicle legislation is identification of the vehicle and of the operator in case of accident. And another is that the knowledge that means of detection are always available may act as a deterrent from lax observance of the law and of the rules of conservative and safe operation. Whatever purpose there may be in these statutes, it is subordinate at the last to the primary purpose of rendering it certain that the violator of the law or of the rules of safety shall not escape because of lack of means to discover him, unquote. The NCAP ordinances precisely require notification of the registered vehicle owner as a means of identifying and discovering the violator of the law. These ordinances mandate the notification of the registered vehicle owner so that he may contest his presumed liability and, where applicable, adduce evidence identifying the actual driver of the vehicle who committed the traffic violation. This mechanism not only affords the notified party of his due process rights, it also implements the very purpose for which the registered owner rule was established. For as held by this court in subsequent cases, where the rule has been consistently applied, the registered owner is considered the employer and the negligent driver his agent for purposes of ascribing liability. Mr. Chief Justice, honorable members of this court, in 2010, the road network in Metro Manila covered 3,091 kilometers. By 2019, Metro Manila's road network had expanded to 4,889 kilometers. Despite the expansion of the road network in Metro Manila, average travel speed stood at 32.86 kilometers per hour in 2013. This dropped to 23.38 kph in 2019. According to the Philippine Chamber of Commerce and Industry, an estimated 3.5 billion pesos is lost daily due to traffic congestion in Metro Manila roads. Based on projections from the Japan International Cooperation Agency, or JICA, economic losses could swell to 5.4 billion pesos a day in 2035 if traffic congestion is not addressed. This traffic congestion is traceable to the ballooning number of vehicles found on the roads of Metro Manila. In 2022, the total number of vehicles in the NCR registered with the LTO was at 1,372,622. As of October 2022, NCR vehicle registration was 3,122,884, an increase of 127% in just over 20 years. Meanwhile, traffic violations have also been increasing exponentially. In 2002, there were 162,364 traffic apprehensions in the NCR handled by the LTO. In 2019, prior to the pandemic, traffic apprehensions in the NCR reached 250,767. These statistics underscore the need for innovative solutions to our ever-worsening traffic situation. The NCAP is one such solution. In a recent survey conducted by Pulse Asia, it was shown that 8 out of 10 persons asked supported the establishment of the NCAP. We therefore pray that this most honorable court green light the NCAP's re-implementation, especially at this point when government has embarked on the difficult task of reinvigorating our economy devastated by the pandemic. To this end, the state most respectfully prays for the immediate lifting of the court's temporary restraining order. Mr. Chief Justice, the honorable members of this court, we reiterate the right to use vehicles in public roads is a mere privilege. That privilege comes not only with a duty to ensure the safety of pedestrians and travelers, but also with our collective obligation to ensure that our roads continue to serve the ends of our national economy and benefit each and every one of us. Our concerned national regulatory agencies and local governments have joined hands to ensure that this privilege is not abused. Through the NCAP, they have established a mechanism to manage traffic and hold accountable those who abuse their privilege to use our roads. We therefore implore this most honorable court to find the NCAP in accord and conformity with our laws. Thank you, and may it please the court.
Thank you, Mr. Solicitor General. Justice Dimampa will start the interpellation.
Thank you, Chief. Good afternoon to one and all. I have 4 sets of questions for the petitioners. In GR number 261-892, these questions must be answered by Attorney Hua, given that he is the one. You wait. Number two, set of questions. In GR number 262-192, these questions must be answered by Attorney Pa. Third set of questions in GR number 263-752, these questions must be answered by Attorney Arugay. And the fourth set of questions deal with common questions, so this must be answered by Attorney Pua, Attorney Pa, and Attorney Arugay. Let me start with Attorney Pa.
Good afternoon, Your Honor.
Good afternoon, Attorney Juman Pa. Section 5, paragraph 2 of Article 8 of the 1987 Constitution provides that the Supreme Court shall have the power to review, revise, reverse, modify, or affirm on appeal or certiorari final judgment and orders of the lower courts involving the constitutionality or validity of any law, ordinance, or regulation. From this constitutional provision, it is quite clear that lower courts, such as the regional trial courts, may pass upon the constitutionality or validity of an ordinance. Correct?
Yes, Your Honor.
In fact, that is the clear-cut pronouncement of the Supreme Court in the case of Planters Bank versus Vertical Philippines, volume 572, Philippine Reports 270. Given that the issuance of an extraordinary writ is within the competence of the lower courts, such as the regional trial courts, it is in these courts that the reliefs must first be sought. That is the doctrine of hierarchy of courts, correct?
Yes, Your Honor, definitely.
In the Geos versus Samar Inc. versus DOTC, volume 849, Philippine Reports 120, the court explained that when the case at bench involves factual issues or questions, so necessary for the resolution of a controversy, the case must be dismissed by virtue of that doctrine of hierarchy of courts and must be brought to the trial court. Correct?
Yes, Your Honor.
Have you read that landmark case of Geos Samar Inc. versus DOTC, promulgated on March 12, 2019?
Candidly, Your Honor, I did not read that case, Your Honor. But in this case, Your Honor, regarding the hierarchy of court, I adopt, Your Honor, the case of Spark versus Manila, Quezon City, and Nabotas, Your Honor.
Let's dwell on this case first.
Yes, Your Honor.
Are you admitting that you are not familiar with the so-called decisive test or factor?
Yes, Your
Laid
Honor.
down in that case. Now, let me apprise you about what the court said in that case. The decisive test or factor is not whether the case is transcendentally important, but whether the factual resolution of issues or questions is indispensable for the disposition of the case. Have you not read that clear-cut pronouncement of the court?
Yes, Your Honor.
Is this the first time to hear the decisive test or factor that will determine whether there can be a direct recourse to this court?
On that particular case, Your Honor, I'm not familiar. But with regard to transcendental importance, but I read the case of Factoran, Your Honor.
Yeah, it is also in that case where the Supreme Court laid down 8 exceptions to the doctrine of hierarchy of courts. But since you are admitting that you have not read the case, I will not ask you about these exceptions. Okay, on pages 22 to 23 of your petition, GR number 26189 262-192. You were aware, one, in the raising issues regarding alleged violation of the right to privacy, you allege, one, that the INCAP website of Manila lacks necessary security protocols. Number 2, that the consent of the subject data was not secured prior to the operation of this website. And 3, the access was granted to the private contractor, correct?
Yes, Your Honor.
Do you agree that in resolving the issues regarding alleged violation of the right to privacy as you rise in your petition, and which is one of your primary arguments, the court has to receive and evaluate evidence, and as such may be considered in the resolution of a factualization.
Yes, Your Honor.
So are you now admitting with that answer that this must be dismissed for violation applying the Samar, Samar doctrine?
It should not be dismissed, Your Honor, because in this case, like my case, Your Honor, it's also applicable that this issue is a transcendental importance, as it involves public money supposed to be for the purse of the government, but it appears that the private service contractor has been enjoying at the expense of the motorist, Your Honor.
Since the alleged violation of the Data Privacy Act of 2012 is one of the issues as agreed upon in the preliminary conference, the National Privacy Commission is the national agency mandated to administer and implement Data Privacy Act of 2012, Republic Act 10173, and to monitor and ensure compliance with the country's international standards set for data protection. You must be aware of the doctrine of exhaustion of administrative remedies, which provides that when the law, which dictates that when the law provides for a specific remedy, relief must be sought by exhausting such remedy before judicial intervention may be availed of. Correct?
With regard to that jurisdiction, Your Honor, I do not agree that the National Privacy Commission has jurisdiction in relation to my case, Your Honor.
Yes, answer the question. I am apprising you about the state policy embodied in the law.
Yes, definitely, Your Honor, the National Privacy Commission.
Okay. Now, did you file or lodge a complaint before the National Privacy Commission?
I did not, Your Honor.
Why did you not file such a complaint?
Because, Your Honor, I'm assailing the ordinance of the City of Manila, and it violates my right to privacy. And the National Privacy Commission has jurisdiction over the violation of the enumerated under that law. In this case, Your Honor, I want to declare the unconstitutionality of the ordinance, particularly the violation of data privacy, which wherein they did not secure my consent, Your Honor. So in this regard, the National Privacy Commission has no power to declare regarding unconstitutionality of my petition.
You do aware that the Supreme Court is not a court of first recourse. In fact, it is a court of last recourse. What provision in the Constitution can you cite to bolster or support your petition in taking direct recourse to this court?
Regarding the declaration for the constitutionality of an ordinance, Your Honor, it is within the original and concurrent jurisdiction with the RTC, Court of Appeals, and Supreme Court to declare the unconstitutionality of a particular issue. And also the petition for certiorari, for mandamus, quo warranto, habeas corpus is also applied in this case, Your Honor. So there would be no violation of the hierarchy of court in this regard, because we can go directly to the Supreme Court. And in fact, Your Honor, my issue is time is of an essence. If I filed with the RTC, it takes around 3 days up to 20 days that the TRO can be lifted. Unlike in this case, Your Honor, I want to file with the highest court of the land to declare the unconstitutionality, and also that the TRO can be effective until it was lifted, Your Honor.
Are you not familiar with Section 5, Paragraph 2A of Article 8 of the 1997 Constitution? You are not familiar with that?
Familiar, Your Honor.
What does it say? Is that the one that you invoke in filing this petition directly with the court?
Your Honor, I'm not, I cannot recite verbatim, Your Honor, that particular provision, Your Honor.
Thank you. In the meanwhile, may I ask Attorney Pua? Thank you.
Thank you, Your Honor.
To answer these questions. You mentioned on pages 9 to 10 of your petition that you filed this petition with this court for 2 reasons. One, to avoid multiplicity of suits, and number 2, to obtain a uniform ruling on the same question of law, correct?
Yes, Your Honor.
Are you familiar with the case of Spark versus Quezon City, volume 815 of Philippine Reports, page 1067, promulgated on August 8, 2017?
Yes, Your Honor.
Okay. In that case, it involved the validity of a curfew ordinances. You recall the ruling of the court in that case?
Yes, Your Honor.
Well, what's the ruling of the court?
In essence, Your Honor, the dishonorable court nullified the ordinance of City of Navotas as well as City of Manila and affirm the validity of the ordinance of Quezon City.
Okay. The case of Jus Samar versus DOTC was promulgated on March 12, 2019. This case was rendered on August 8, 2017. Now, in this case, it would appear that the difference boiled down to the specifics of the implementations of the ordinances of Manila, Navotas, and Quezon City. By arguing that filing directly in this court would lead to a uniformity in the ruling on such ordinances, is the court precluded from rendering different rulings as in the case of Spark? In this case,
The Regional Trial Court, Your Honor, or this is, sorry, Your Honor, may
in the Spark case, the court allowed direct recourse. Now, in that case, the court ruled that the ordinance of Quezon City, as you have said, was declared valid, whereas the ordinances of Manila and Navotas were declared invalid. So the court rendered that different rulings there. Now, in this case, which involved the ordinances of 7 local government units, is the court in these proceedings precluded from ruling differently on the ordinances as in the Spark case?
no, Your Honor.
On the other issues, what injuries have you suffered to invoke this court's jurisdiction over your present petition?
The injury of the members of the petitioners, Your Honor, not to be to be liable in case of the traffic violations committed by the drivers, Your Honor.
You stated in your petition that you represent PUP operators, transport organizations, drivers, and transport workers. Are you representing them as a representative in class?
No, Your Honor. The petitioners are the national transport organizations who has members who are public utility vehicles operators, Your Honor, filing on its, thus, Your Honor, the petitioners as a separate juridical entity is filing filed this petition on its behalf on behalf of its members.
To reiterate, you stated on pages 8, 9, and 10 of your petition that you intend to secure from this court a uniform decision on the same question of law and to avoid multiplicity of suits. How come that you did not disclose in your certification of non-forum shopping that you filed a similar case before the RTC of Makati subsequently raffled off to branch 57?
Your Honor, because there's no similar parties, like there's no identity of parties and issues involved, Your Honor. In the Makati case, Your Honor, In the Makati case, Your Honor, it is our law office, Malcolm Law Office, who is the petitioners, Your Honor. Here, Your Honor, we are the counsel of the petitioners, Your Honor. While one of the petitioners, KAPIT, was a party in the Makati case, its case was dismissed, Your Honor, and no motion for reconsideration or appeal was filed questioning the order of the regional trial court. And further, Your Honor, when we filed this case, Your Honor, MMDA was not a party to our petition, Your Honor.
But the cold hard fact is that you represent KAPIT, stood up as a Mazda and ACTO.
Yes, Your Honor. That's the precisely, Your Honor, we did not include MMDA in our petition.
You assailed before that RTC of Makati raffled off the grounds 57 the validity of MMDA Resolution 16-01.
Yes, Your Honor.
And here you are assailing the validity or constitutionality of the ordinances of these 5 local government units?
Yes, Your Honor.
Is that your theory that in light of this, you need not disclose the case filed before the RTC of Makati because there is no similarity of issues?
Similarity of parties and issues, Your Honor.
Remember the purpose of the certification of non-forum shopping. You must disclose any similar case that you have filed. You are under oath, and please answer the questions truthfully. You stated in your petition that we have relaxed the rules for certain cases or issues. Why should we relax the rules when you clearly did not follow the simple rule on the certification of non-forum shopping?
Your Honor, as when the instant petition was filed, Your Honor, MMDA was not a party to the petitioner's petition.
An examination of the petition reveals that you pray for the invalidation of the INCAP ordinances. However, we know that these ordinances emanate from the MMDA resolution number 1601. Based on its comment, pages 50 to 51, the MMDA claims that resolution number 1601 is separate and distinct from the INCAP ordinances. Now, suppose the Supreme Court invalidates in these proceedings the assailed ordinances, what would be the effect of such ruling on MMDA resolution number 1601?
Nothing, Your Honor.
No effect at all.
Yes, Your Honor.
As you know, the court has the power to grant just and equitable relief other than those expressly prayed for in the pleadings. Considering that the INCAP ordinances are essentially options of MMDA Resolution number 1601, can the court also declare the said resolution unconstitutional in these proceedings?
Yes, Your Honor.
Thank you. I'll ask you again. May I request Attorney Arugay to answer these questions?
Good afternoon, Your Honors.
Good afternoon, Attorney Arugay. You mentioned on page 9 of your petition that you have already filed a petition before the RTC of Manila, impugning the validity of Manila's income ordinance resolution. And that this petition, that said petition was dismissed and is now the subject of a motion for consideration, correct?
That is accurate, Your Honor.
You also mentioned in your petition that the reason you filed this petition before the Supreme Court is because the regional trial court suspended its own proceedings, correct?
Not exactly, Your Honor. What we stated in the petition is that the Regional Trial Court of Manila issued an order deferring the resolution of the MR filed by the counsel of the petitioners in this case before the RTC. The case before the RTC, Your Honor, is not being handled by this representation.
You mean there is a difference between deferment and suspension?
No, Your Honor. I just wanted to be as accurate as possible, Your Honor.
You were not the counsel before that petition filed in the RTC of Manila.
No, Your
Correct?
Honor.
Do you agree that the disclosure in the certification against forum shopping of the pendency of a case does not mean that you can subsequently file a similar case in another court?
Definitely, Your Honor.
Does the suspension of proceedings by the RTC of Manila mean that you can also file the instant petition before another regional trial court or before the Court of Appeals?
While it is true, Your Honor, that the disclosure in the certificate against non-forum shopping is a distinct act from the existence of forum shopping itself, it must be stressed, Your Honor, that the evil sought to be avoided by forum shopping is the existence of contrary decisions among various courts, Your Honor. In this case, the RTC of Manila itself suspended its proceedings as judicial courtesy to this court. That leaves the petition without any plain, adequate, speedy remedy, Your Honor, to further address their concerns pertaining to that petition. Hence, the resort to this honorable court, Your Honor.
Suppose your petition before the RTC of Manila was in fact granted. And it was the City of Manila which had a pending motion for consideration before the RTC. Would you have still filed the case before the Supreme Court?
Since it is a hypothetical situation, Your Honor, that would largely depend on whether or not the RTC of Manila will suspend the proceedings of that particular MR filed by the opposing party, Your Honor. If the RTC of Manila suspends the proceeding in deference to the proceedings before this court, then definitely, Your Honor, we will be back before this honorable court to assail, to allege the same violations pertaining to the Constitution.
Is it not possible for you to wait for the suspension of the proceedings before the RTC to be lifted before, instead of filing your petition before this court?
We would have, Your Honor, had the earlier petitions included the arguments raised in our petition, which in particular, Your Honor, has something to do with the supplanting of the jurisdiction of the courts of justice, which were never raised in any of the earlier petitions.
Would you not stand to benefit from the fact that another party is arguing to invalidate the income?
The grounds raised by the other petitioners, Your Honor, is not akin to the grounds that we raise in our petition, and their situation is definitely different from the situation of our clients. So in that sense, Your Honor, we were compelled to come before this honorable court to raise those allegations, Your Honor, if only to increase the chances of having a more reasonable or a beneficial decision, Your Honor.
I have two common questions
Yes, Your
for the three petitioners. You must first answer this, and afterwards, Attorney Paa and Attorney Hua will answer same. It is doctrinal in our jurisdiction that the essence of procedural due process is satisfied as long as there is notice and opportunity to be heard, correct?
That is accurate, Your Honor.
A perusal of the assailed ordinances reveals that they provide for one, notice of violation, and two, mechanism to dispute a violation of the ordinance. Can you explain why these are insufficient for purposes of complying with the procedural right to due process?
Batas Pambansa 129, Your Honor, defines violations of traffic laws, rules, and regulations, as well as violations of local ordinances as criminal violations, Your Honor. This is precisely why the said jurisdiction was allotted to the first level court under Section 32, which has the heading of criminal cases, Your Honor. Now, in relation to this honorable Supreme Court issued various rules, Your Honor, that obviously show that these kinds of violations are criminal in character. And therefore, what applies in these types of violations is not simply notice and hearing, but criminal due process.
Thank you. May I ask Attorney Pua, Attorney Pa to answer the same common questions?
Good afternoon, Your Honor. With regard to procedural due process in the application of the NCAP, Your Honor, the ordinance expanded its jurisdiction and even usurped the authority of the LTO. So even the registered owner, Your Honor, should not be penalized, but it should be the driver. So by issuance of notice of violation directly to the owner, registered owner of the vehicle, Your Honor, and he was required to pay for the penalties if uncontested. That is a violation of due process, Your Honor. And it must be penalized the driver and not the motor vehicle owner, Your Honor. So there must be a notice as well as the right to be heard of his case and to present evidence, Your Honor, to the actual perpetrator or infractors.
In your petition, docketed as your number 262-192, you emphasize that one, the notice of violation was sent to a wrong address, and you did not have any opportunity to lodge or file a protest against the violation. This being so, the problem is not with the law. It is with the implementation of the law, correct?
Yes, Your Honor.
Can the court declare a law unconstitutional? Not because of inherently defective provisions, but on account on an isolated instance of erroneous implementation?
Regarding the erroneous address, Your Honor, the LTO, the City of Manila can even refer If the registered owner has a driver's license, definitely, Your Honor.
You answered the question categorically. Can the court declare a law not because of its inherently defective provisions, but on account of an isolated, erroneous implementation of the law?
Yes, Your Honor. It can, Your Honor.
Would that not set a dangerous precedent where the validity of the law is dependent on the acts or mistakes of government employees?
Yes, Your Honor.
What do you think is the appropriate remedy under that circumstances?
In the first place, Your Honor, if there's an ordinance, there must be a limit, parameters or guidelines they need to follow, Your Honor. But in this case, it's totally defective because there is no such procedure in case of the erroneous address, Your Honor. So it can be declared unconstitutional because of violation of due process, the procedural due process in particular.
Can you not file an administrative complaint against the erring government employees?
Your Honor, definitely, I have the intention to file administrative case against them, Your Honor.
Thank you. May I
Thank you, Your Honor.
request Attorney Pua to answer this question? On page 37 of your petition, you stated that a motorist is deprived of the benefit of proximity of time to the alleged occurrence of a purported traffic violation. How would you define this proximity of time? You
Well,
allege that in your petition, specifically on page 37.
yes, Your Honor. In experience of the petitioner members, Your Honor, proximity, the sufficient period of time to contest the traffic violations and to know right there and there what was violated and who violated the traffic regulation, Your Honor.
What time or period are you contemplating as to have a deprivation on the part of the motorist?
The same time that he commits a driver commits a traffic violations and apprehended by a traffic enforcer, Your Honor.
At what point do you think there is sufficient time for a motorist to easily recall an event or traffic violation?
Within the same, that's why, Your Honor, no contact apprehension deprives proximity of time, and our position, petitioner's position is traffic regulations can only be made through face-to-face apprehension.
Can you explain that in your memorandum?
Yes, Your Honor.
Thank you. May I now call Attorney Arugay, please?
Good afternoon, Your Honor.
I'm sorry. Should be Attorney Pua. I'll call you again. No. You stated on page 12 of your petition that there will be deprivation of the right to earn a living if the income is to be implemented as the registered vehicle cannot be used. How is this deprivation made manifest if an operator has several vehicles? under his or her or its inventory.
If of course, Your Honor, if the operator has several units, it cannot be said that he will be deprived of the opportunity to earn the living if not all the vehicles were not able to register, Your Honor.
Do we not consider that there may be other operators whose vehicles are not used or other jobs that are available?
Yes, Your Honor, but jeepney operators, Your Honor, that's their life. And as they say, they live and will die as operator of jeepney.
In such a situation, there will be no deprivation of the right to earn a living.
No, the deprivation, Your Honor, because they have their franchise, Your Honor. They were allowed by the Land Transportation Franchising Board to operate, to serve the public and at least earn a decent income, Your Honor. But if the registration of their vehicles, Your Honor, will be affected and cannot be registered, hence they cannot run, Your Honor. Then hence the deprivation, Your Honor.
Do you think that the ordinances you are assailing meet the required substantive test of validity and constitutionality?
No, Your Honor.
Explain.
One of the requirements of a valid ordinance, Your Honor, is that it must not contravene any statute and the Constitution. A reading of the ordinance would show, Your Honor, that there is a presumption that the registered owner is liable for the traffic violation, Your Honor. But traffic violation, Your Honor, in connection with our traffic code, RA 4136, is personal in nature, Your Honor. But by transferring the liability, the liability of the driver to the registered owner, Your Honor, their rights were violated. By assuming, Your Honor, that they are already presumed liable, their rights are violated, Your Honor.
Are you not aware of the pronouncement of the Supreme Court in the case of City of Manila versus Lagios Jr.?
I'm not that familiar, Your Honor.
95 Philippine reports, it's 289. That's the case where in the Supreme Court laid down the requisites for the validity of an ordinance.
Yes.
There are six. You cannot
Yes,
mention some of these.
It must not be oppressive, Your Honor. It must not be impartial. Must not be unreasonable. And I'm sorry.
Let me zero in on the requisite that to be valid, it must be reasonable. Are you claiming that these assailed ordinances are not reasonable and therefore the same are not valid?
Yes, Your Honor. The subject ordinance are not reasonable.
May I ask again? Thank you. Thank you. Attorney Pa. Okay, let's go to substantive due process. If procedural due process requires notice and hearing, then substantive due process essentially requires the presence of both lawful purpose and lawful means, correct?
Yes, Your Honor.
Can the local government units and the exercise of their delegated legislative powers enact a law that adopts the registered owner rule as mentioned by Solicitor General Guevara. It's really the seminal case on registered owner rule as it was promulgated of September 29, 1957. 102 Philippine Reports, page 103. What does such rule dictate?
The registered owner rule, Your Honor, as far as I know, that is applicable for the quasi-dele case. In case there's an accident and for hit and run, and you cannot find or you have no evidence who the driver is. So under registered owner rule, they may subpoena the owner of the vehicle to determine who is the actual wrongdoer of the crime, Your Honor, under quasi-dele. But in this case, Your Honor, it should not be applicable under the substantive substantive lawyer due process, Your Honor, because it contravenes the law, particularly the registration shall be affected under the registered owner rule that he is required to pay the violation or fees and not the driver who committed the violation.
This is what the Supreme Court said. Registered owner of vehicle, even if not used for a public service, shall be primarily responsible to the public or to third persons for injuries caused to the latter, while the vehicle is driven on the highways or streets. Is there any legal provision which confines to Congress the power to enact such a law incorporating such registered owner rule?
It contravenes, Your Honor, the law regarding the application of that registered owner rule, Your Honor. It's quite confiscatory.
Is there any express prohibition on under the local government code regarding the adoption of the registered owner rule?
As far as I know, Your Honor, I find nothing, Your Honor, to registered owner rule.
Please explain that in your memorandum.
Yes, Your Honor.
Now, again, on the issue of this, the application of the register on the rule, that's the Erazo versus Hefty, as correctly cited by Solicitor General Guevara. And let's analyze this along the requirements of substantive due process. I would like to focus on the presence of lawful means, considering that lawful purpose, which is accountability for a traffic violation, is evident. Is my understanding correct that you were the one driving your car when the traffic violations were committed?
Definitely, maybe, Your Honor. It's because sometimes
You answer. Were you the one driving your car when the alleged violation was committed?
Yes, Your Honor. But because those 4 times of violation, Your Honor, I cannot remember because in 1 year, I traversed that place around 200 days in the morning and 200 times in the evening, Your Honor.
In such instances, there is no issue at all with the registered owner rule, correct?
In my
Given
case,
that-
Your Honor, it may be.
Can you explain?
Your Honor, sometimes I let somebody to drive for me, Your Honor. So if the basis is the registered owner rule and there is a traffic violation, it should be the driver who committed the violation. It's not the owner of the vehicle. Because in the first place, I have no personal knowledge about the commission on the facts, how he committed the traffic violation.
Let us dig further to examine the reasonableness of the registered owner rule as a means of implementing the in-cap ordinances. Do you lend your car to strangers, Attorney Pa?
Sometimes they borrow my car, Your Honor.
Of course, that since you only lend the car to someone on whom you have some level of trust.
Yes.
Now, when you lend your car to someone you know, is there a risk that said person would figure in an accident?
Yes, Your Honor.
How about traffic violation?
I always informing my the person, Your Honor, about the not to commit any traffic violation, Your Honor.
When you allow another person to drive your car, you already know that there are risks that accompany such an arrangement, which involve violation of a traffic regulation, correct?
Yes, Your Honor. But it is based on his overt act, Your Honor, for committing that. So he should be liable and not me, Your Honor.
Let me move on to another question. Would it not be possible that in certain instances, the local government unit would have knowledge, but you yourself would not have any idea as to who is driving your car?
Yes, they do not have any idea, Your Honor, because usually they capture the CCTV footage at the back, Your Honor, at the back of the car. So instead of putting that CCTV at the back, they have to put a place on the front so that they can definitely identify the driver who committed the violation. So that's unreasonable, Your Honor.
Basically, you can lend our cars to anyone since we have no law prohibiting a car owner from allowing another person to drive his or her car, correct?
Yes, Your Honor.
So as a general proposition, do you agree that in view of multiple issuances of instances of borrowing and lending, it would be almost impossible for the local government unit to determine the identity of the person driving your car at a particular time?
They can identify, Your Honor, because according to them, they installed the state-of-the-art camera. So how come that they cannot identify the driver of the motor vehicle, Your Honor?
Wouldn't you agree then that common sense dictates that the local government unit would necessarily have to rely on the registration of a vehicle in imputing liability and accountability in cases of traffic of infractions?
They're not allowed to do such law, Your Honor, in that particular regard. Because it's so hard, it's so hard on the part of the owner of the motor vehicle. For example, if the one who committed the crime, Your Honor, using the motor vehicle is the driver or somebody. So you're imputing the liability, criminal liability, to the owner. So that's unfair, Your Honor.
Is the registered owner rule then not reasonable, since it merely ensures that the person who has traceable control over the car can be held liable for a traffic violation.
Yes, Your Honor, that's unreasonable. And also under substantive law, Your Honor, that they're imposing the additional requirement, Your Honor, for those the owner, motor vehicle owner to pay.
By the way, is there no way to contest a notice of violation in instances where the person held liable was not actually the one driving the vehicle?
Like in my case, Your Honor, I noticed they informed me, the LTO, that my car cannot be registered without having paid the penalty. So I went to MTPB. I talked to Wendell. He discussed to me the reason why I did not receive any violation. And even asked the adjudicator and even the chief of MTPB to waive the penalty that I have. But I have no recourse, Your Honor. He instructed me to just pay the penalty. The penalty itself plus the exorbitant fees, Your Honor, plus using of the machine. Per transaction, I need to pay 35 to 45 pesos.
Would you agree then that all of these factors working together make the registered owner rule a reasonable means of determining liability and accountability in cases of traffic infractions?
So I think it's not reasonable, Your Honor. It can be applicable only to quasi-delict.
You explained that in your memorandum.
Thank you, Your Honor.
In the case of Vivaris versus St. Teresa's College, volume 744, Philippine Reports 451, which the respondent MMDA cited on page 41 of its comment, the Supreme Court mentioned 3 strands of our concept of privacy. They are locational or situational privacy, informational privacy, and decisional privacy. Of these 3, which particular strand may be relevant to your case?
The transactional privacy, Your Honor.
Informational.
Informational.
Okay, you have read the case? You should have read the case
yes,
because
Your
you
Honor.
cited that in your petition.
Yes, Your Honor.
Okay, what do you understand by this strand of informational privacy?
It means that the government agency cannot interfere with the private life or right of privacy of the person. When we talk about the private life, Your Honor, it's not limited to our activity in everyday life, but also involves information about the personal data of the person. Like in my case, applicable, they divulge the information regarding my name, the address recorded with the LTO, but not the address indicated in my driver's license, which is a correct one, Your Honor. The MB motor vehicle file number, Your Honor, which is the very genuine identity of the car, as well as the brand, year, model, they provided those information. So in my case, Your Honor, I've been handling cases, more particular drug cases, and even I have been subject for casing. I know that, Your Honor. So they can easily conduct surveillance against me by looking the information regarding my car to determine my exact address.
So based on your example, how do you now define informational privacy?
It is the privacy.
It is the right of individuals.
The right of the individual, Your Honor, who expected reasonable expectation that the privacy of his life or private life should be protected, Your Honor, without interfering on the part of the government, much more on the public.
It is the right, as emphasized by the court in that case, of individuals to control information about themselves.
Yes, Your Honor.
I would like to clarify your legal theory with respect to the violation of the right to privacy. Is the issue related to specific provisions of the assailed ordinances or the implementation?
I think, Your Honor, it's on the other ordinances itself as well as the implementation. Because the ordinances, Your Honor, it provides on how to secure the data. They will link directly to the LTO using the service provider.
Okay, having said that the issue may relate to specific provisions as well as implementations, can you point out specific provisions? You are selling the ordinance of Manila.
I cannot.
We assume that you have read that. Can you point out specific provisions therein as well as implementation that may involve a violation of the right to privacy?
I cannot specify in particular, Your Honor, a particular section, but as far as I remember, it is the implementation of the NCAP. They will provide the motor vehicle alert system. Yeah, the alert system, Your Honor, they collect data from the LTO. The LTO will allow them to access the database. So in that case, Your Honor, they committed violation of right to privacy for not securing our consent as a motor vehicle owner, Your Honor.
Since you invoke a violation of the right to privacy under the Data Privacy Act of 2012, Republic Act 1173, are you aware of Section 4E of the law?
Yes,
Section
Your Honor.
4E. What does such provision state?
Regarding the data that can be accessed.
I will let you. That's an exception to the rule. What is that exception all about?
I cannot remember, Your Honor.
Information necessary. The Data Privacy Act of 2012 is not applicable to information necessary in order to carry out functions of public authority, which includes the processing of personal data for the performance by local enforcement and regulatory agencies of their constitutionally and statutorily mandated functions. Are you now familiar with that?
Yes, Your Honor.
You mean that that exception is not applicable to your case?
Definitely, Your Honor, because it involves the third party who can access directly with the database of the LTO. The LTO is what we call the controller. They have they can negotiate with the city of government as the processor. But in this regard, the presence of the private contractor, Your Honor, under service agreement, they can access directly with the database.
Thank you. May I now ask Attorney Rugay to answer this last set of questions?
Good afternoon, Your Honor.
Good afternoon. Attorney Arugay, on page 34 of your petition, you allege where that the INCAP violates certain provisions of the revised penal code. Can you expound on this? Can you cite
Yes, sir.
which provisions of the law are you referring to?
Your Honor, the revised penal code defines, in defining the various types of offenses, Your Honor, recognize that fine is a mode of penalizing a criminal offense. In fact, in defining light offenses, the revised penal code states that offenses penalized with fine of not more than 40,000 pesos shall be considered as light offenses that prescribes in 2 months, Your Honor. In the instant case, the fine that is usually imposed in NCAP violations ranges from 500 pesos, I think, up to 10,000 pesos, which all fall within the ambit and definition of light offenses. Now, Your Honor, if we're going to check the procedure being embraced by the NCAP ordinances, Your Honor, it would seem that the local government units practically have unlimited time within which to prosecute these violations. In fact, it is reported by our clients, Your Honor, that they have received notices of violation more than 6 months from the alleged date of commission. So this is a clear, obvious skirting away, Your Honor, of the provisions provided under the revised penal code. Furthermore, Your Honor,
Specific, I am asking you specific provisions of the law. You allege that in your petition, page 34. Can you tell us or point out specific provisions of the revised penal code?
the
You are
petition, yes, I'm very sorry, Your Honor. The petition itself does not cite any specific provision. If I remember it right, that a single revised penal code provision was actually cited in the petition itself, Your Honor.
Precisely, I'm asking you
But
to
if we are,
expound on that.
yes, Your Honor. The definition of light offenses is provided under Article 8, I think, of the revised penal code, whereas the prescription of offenses provided under Articles 90 in relation to 91 of the revised penal code, Your Honor.
In your view, Section 29 of Republic Act 4136 allows only the face-to-face apprehension of the driver concerned, correct? That's on page 32 of your petition.
That
Correct?
is our submission, Your Honor.
Does the language of the statute clearly exclude other modes of apprehension?
It does not, Your Honor.
Does no contact apprehension prohibit the Land Registration Commission, now the Land Registration Office, from enforcing the provisions of Republic Act 4136 within the territorial jurisdiction of the respondent local government units?
It does not, Your Honor.
Just to confirm, the commission referred to in the law, Republic Act 4136, is the Land Transportation Commission, which is now the Land Transportation Office, correct?
Yes, Your Honor.
Why did you not implement that in your petition?
Our fundamental objections to the ordinances, Your Honor, is the encroachment upon the jurisdiction of the courts of justice, as well as the violations of due process. The purported violation of our Republic Act 4136 are ancillary issues which we only incorporated to strengthen our position. But a perusal for petition, Your Honor, will show that the main gist of our petition is precisely the lack of jurisdiction of the adjudication boards in exercising jurisdiction over violations of traffic laws, rules, and regulations, Your Honor.
You argued in your petition that the city of Manila's grant of jurisdiction over cases involving traffic violations encroach upon the powers of Congress
Yes, Your Honor.
to apportion the jurisdiction of the courts, correct?
Yes, Your Honor.
Okay. can you point to a specific provision in the ordinance which states that the metropolitan trial courts or municipal trial courts, as the case may be, would no longer have jurisdiction over traffic violations of traffic laws?
The first level courts are never mentioned in the ordinances. However, the ordinances, Your Honor, specifically state that the adjudication board shall exercise exclusive and original jurisdiction over violations of traffic laws, rules and regulations, Your Honor. That is an exclusionary provision, Your Honor, to the exclusion of all other entities, including the first level courts, Your Honor.
Can you point to a specific provision which states that the decisions of the traffic adjudication board must be appealed directly to the regional trial courts?
There's none, Your Honor.
There's none. Absent such provision, can you still say that the jurisdiction, are you now advancing the view in the absence of such specific provision that the jurisdiction of the Metropolitan Trial Court had not been encroached?
Absolutely not, Your Honor. On the contrary, by stating that the adjudication boards shall have exclusive original jurisdiction over violations of the NCAP provisions, Your Honor, would run contrary to the grant of jurisdiction to the first level courts, Your Honor. In fact, if we're going to check the proper proceedings, if we're going to follow the logic put forward by the ordinances, Your Honor, the only available remedy for a violator or alleged violator, Your Honor, that was convicted and fined by the adjudication board would be to file a Rule 65 petition before the RTC. When in truth and in fact, Your Honor, I'm sorry, Your Honor.
Okay, continue.
When in truth and in fact, the violation of the traffic laws, ordinances, as well rules and regulations, Your Honor, should have been prosecuted before the MTC or the first level courts, just like other ordinances, Your Honor, pertaining to non-smoking, pertaining to mandatory wearing of face masks during the pandemic. Why is it, Your Honor, that NCAP provisions is being insulated from the same proceedings when all of those other ordinances are actually being prosecuted before the first level courts? That, Your Honor, is our fundamental objection.
Is the how do you now describe the proceedings before the Traffic Adjudication Board? Administrative or judicial?
It would appear, Your Honor, based on the ordinances, that they exercise quasi-judicial functions, which unfortunately, Your Honor, was never mentioned under the local government code. If the LGU does not possess the power to exercise quasi-judicial functions, Your Honor, much less should they be allowed to delegate this power to an adjudication board.
Suppose we rule that the adjudication board cannot hear cases involving violations of traffic rules. Would it now mean that in order to hold thousands of traffic violators liable, the city of Manila would first have to initiate thousands of complaints before the MTC?
Respectfully, Your Honor, this position is exactly what was adopted by this court in stating in the rules on summary procedure and the rules on expedited proceedings before the first level courts that the Metropolitan Trial Court shall hear and decide traffic violation cases, Your Honor. This is not the position of Atty. Arugay. This is the position adopted by BP 129 as well as by this honorable courts in its various issuances, Your Honor.
Should this also be the case for violation of other ordinances?
I'm sorry, Your Honor.
Should this also be the case for violation of other ordinances, such as, for example, those relating to business permits, fire permits, where a fine can be imposed, a case must first be filed before the MTC.
There's an obvious distinction, Your Honor, between those types of ordinances and ordinances which are penal in character, Your Honor. While it would seem that the Office of the Solicitor General adopts the view that this is an administrative fine, since the ordinances are regulatory in character, it is obvious, Your Honor, that fine is a mode of penalizing a crime. So only those ordinances, Your Honor, or traffic laws, rules and regulations that impose the penalty of fine in the nature of a penal provision, Your Honor, should be filed with MTC, just like other ordinances such as non-smoking, mandatory wearing of face masks, and so on, Your Honor.
Wouldn't this significantly add to the burden of both the local government units and the courts?
I would submit, Your Honor, that it would burden the first level courts, Your Honor. However, the courts of justice must not shy away from the exercise of the power that was granted to it by the Constitution. In addition, Your Honor, if the first level courts will have jurisdiction over these cases, it would seem, I think, the fine would be would devolve to the benefit of the state, Your Honor, instead of being used exclusively by the LGU and partly paid to the service provider, Your Honor.
Are traffic violations under the INCAP criminal in nature, which are cognizable by the regular courts?
This is definitely criminal in nature, Your Honor. If the first level courts would exercise jurisdiction over simple matters as violation of the non-smoking rule, then more so by traffic violations which endanger the society and the people in general, Your Honor, or as stated in the video, the pedestrians, Your Honor.
Can you tell us now what kind of traffic law violations you are pertaining to that come under the criminal jurisdiction of the first level court?
Most traffic violations, Your Honor, would come within the criminal jurisdiction of the courts, Your Honor, such as beating a red light or reckless driving and so on, Your Honor. In fact, it is not a new concept that traffic violations fall within the jurisdiction or criminal jurisdiction of the courts, Your Honor. For example, reckless imprudence resulting in damage to property involving traffic accidents, Your Honor, fall within the criminal jurisdiction of the court. So I don't see any reason why violations of the NCAP should be insulated from the same rule, Your Honor.
Enlighten this court how a traffic light violation will be subject to the regular court's jurisdiction instead of the traffic adjudication boards of the respective local government units.
Based on the arguments put forward by the Office of the Solicitor General, the tendency might be to consider the adjudication board as having primary jurisdiction over all of these violations, Your Honor. But the doctrine of primary jurisdiction has no application with respect to the adjudication board because that is reserved particularly to government agencies which have specialized knowledge in implementing various laws. In this case, Your Honor, while the LGU have special knowledge with respect to traffic regulations that are applicable within their locality, they are without any expertise with respect to the judicial process in exacting the fine, Your Honor, in accordance with the right of an accused provided under the Bill of Rights.
Last two questions. Is a lane marking violation subject to the jurisdiction of the regular courts?
Your Honor, the best solution to this question is legislation, not judicial legislation. This is exactly why, Your Honor, in the 18th Congress, my co-counsel, Attorney Jerome Christopher Lanes, with the help of Deputy Speaker Liachon, Your Honor, authored a bill that actually implements the NCAP. And that bill, Your Honor, was passed by the lower court but was never approved by the Senate. But in that bill, Your Honor, a copy of which I have with me, the Congress itself recognized the fact that adjudication boards or LGUs do not have jurisdiction, which is why they created a new adjudication board that shall exercise jurisdiction over cases or primary jurisdiction over cases pertaining to NCAP violations. And in that bill, Your Honor, the type of traffic violations that should be within the criminal jurisdiction of the courts was also clearly defined and delineated. This is a matter, Your Honor, that is best addressed by legislation instead of sustaining the NCAP ordinances as they are right now, Your Honor.
Well, how about entering one-way streets? Will you maintain the same line of argument or theory, one-way streets.
That type of violation, Your Honor, I would say is criminal in character. Considering the danger that it poses to pedestrians and other vehicles that may be traversing the same street.
What do you think? Will that fall under the jurisdiction of the regular courts or under the local government units?
Our position, Your Honor, it is our submission that these types of violations, Your Honor, which are penal in character, criminal in character, should fall within the criminal jurisdiction of the courts of justice.
Thank you.
Thank you
That
very
will
much.
be all, Chief.
We suspend the proceedings, the interpellation for the Solicitor General will be made in the next session. But in the meantime, can you submit to the court within 5 days from today the actual or sample of a duly issued NOV by the MMDA and the local governments concerned? Attorney Pa, submit to the court the assessment that was made by the LGU of Manila as regards the payment which you made, which included the surcharge and the interest.
Yes, Your Honor. And I would like to manifest that I already appended that assessment, Your Honor, on
Yeah.
my...
No, the assessment is not there. I read your petition. What you attached were the receipt of payment. But as to the detailed assessment coming up with 20,000, we want to see that.
Yes, Your Honor.
Okay. Also, we should submit to the court also the articles of incorporation of the contractor and also the documents regarding the income generated in the course of the implementation of this NCAP by the LGU. Also submit to us the document of the original proponent rule, which was the basis of the Quezon City JBA. We noticed in the other JBA from other local governments that there is no mention that there was an original proponent offer for this kind of joint venture agreement. Only Quezon City mentioned that there was an original proponent and they published the offer and requested for a Swiss challenge. But we have yet to see it in the other JBA. So, yeah, if there are B documents supporting the JBA, please submit that also for all LGUs. So, for MMDA, also send us a copy of your NOV under 1601. The copy of the NOV must be both pages, front and back, so we can see what is the content of NOV issued to these violators under the no contact policy. Okay. So, for the record, we will state that this afternoon, the Solicitor General, as well as the petitioners, made their respective presentations. And Justice Di Mampao commences interpellation on the petitioners and the succeeding hearing. Justice Di Mampao will proceed with his interpellation on the Solicitor General. Okay, let's be clear. The submission of the documents, I said earlier, is 5 days from today, non-extendable. Thank you. Okay. The next setting, as originally stated in the advisory, is January 24, 2023 at 2 p.m. Yes, Attorney Pa.
Your Honor, we prepared the video presentation. It may be allowed to present this one. We will reflect the income reported as what you requested, Your Honor, for the counterpart, which is QPAX System Traffic Incorporated and QPAX Traffic Manila. In this case, Your Honor, they created the ordinance to conform the service agreement entered into in 2014. There is no such JBA submitted by the City of Manila. There's only a supplemental service agreement. So may presentation, Your Honor, you may notice how they collected from fines around 75% from the collected fees and penalties from the motorists. It should be for the government. It takes around less than 10 minutes, Your Honor.
Okay, you just submit it in the next hearing. Okay, just submit it to the court in the next hearing. And then tell us, submit to us all the documents, as I said, within 5 days from today. Your document, you can submit that also within the next 5 days. 5 days. Yes, Mr. Solicitor General.
Your Honors, we are made to understand that the continuance of the oral arguments will be held on January 24 of next year. So it only means that the resolution of these petitions on the merits will be sometime next year. Of course, we will have to deliberate after the oral arguments have been concluded. So in the light of this development, Your Honor, we are actually hoping that we'll be able to finish the oral arguments today. But in the light of these developments, which are perfectly understandable anyway, Your Honors, may the OSG on behalf of the LTO and the MMDA and the Republic in general respectfully request that its prayer for the immediate lifting of the temporary staying order be considered by this honorable court in the meantime. Thank you, Your Honor.
We'll take into account your plea today. Precisely, you want to see the documents immediately. That's why we're giving you 5 days. So we can take a look at it. Madam Clerk of Court, are there any other matters?
There are no other matters, Your Honor.
There being no other matters to take up, this session is adjourned to resume on January 24, 2023 at 2 p.m. Thank you.
You're